I'm paying for a listing for WPC matter.
For what?
Functioning of the BU committee, functioning of the.
You mentioned it before regular bench. Which bench?
की matter
Key matter.
WPC.
education में
Department
की department आता
You mentioned it before the regular bench. Bench 4 or 5.
है education में है करने
Yes, yes, yes.
Full, na?
Yes.
My lord, item 1, 4, 5, 6, my lord, out of same order, my lord.
Ah.
Same judgment, and I am told by my learned friend, my lord, some of them have died. The respondent, and some of them has been
retired
retired. So we need, my lord, some more time be granted, my lord, around 6 weeks.
So the order is not complied.
Not yet compliant till date.
It is for release of
Salary only.
payment. What has been done? You belong to which category?
I belong to, my lord, category of 88, 89 category, my lord.
This is with regard to those 3 categories where some were legally appointed, working, not getting salary.
My lord, I was, my lord, appointed in access post.
Excess post.
Access post.
But by regular means. Regular means or
In regular means, my lord, up to 2007, we have received our salary.
Mr. History what?
Lordship here R Muzumdar he was appearing of the earlier
Oh, see this 310 order.
Yes.
310/2019 order.
yes Lordship last it was listed on 11/5/2022 where it was segregated earlier all those cases were tagged in a series lawsuit.
Hmm.
Now then on 11/5/2022 it was all segregated and thereafter it was listed for the first time. And the respondent 1 has retired long back, 2 has been expired lawsuit. So R Muzumdar he was
That
Respond-
is all right, but
present.
essentially this is a question of release of salary.
Yes, lordship.
So the government will have to. There is already a specific order on this 310/2019.
Yes.
And it says that do you have a copy of this order?
No, lordship. I am not in this contempt because R Muzumdar he is a lord.
I know, but you belong to the education department.
That is there, but
The orders are there.
in contempt earlier lordship
Where
they
is
were
Mr. Mazumdar?
On legs in court, my lord.
So you are there, you tell us what has happened. There is a specific order of compliance. Now, who expired here?
the director earlier SK Bhuya expired and Tikam Sekia he was retired almost 3 to 4 years back.
No, retirement is okay, but at the time when he was in service, he was required to comply with the order. Who expired? SK
SK
Bhuya.
Bhuya.
Okay. And then
And Tikam Sekia retired.
retired. Yes, Mr. Bhuya,
My lord,
You want to implement lordship, let him implement if you want.
you want to impede.
you have to implement, my lord, otherwise, my lord, if order has not been complied with, as on date.
There was a direction here to file a compliance report.
My lord, that has not been done.
When is it likely to be available?
Next week, my lord.
No. R Muzumdar. I want to.
You said he's on legs.
On legs.
Yes, how long?
My lord, I can't say right now. I'll inform you.
You call him, you inform him.
Hello.
Let us find out what is there. Please inform him.
4, 5, 6 also same, my lord, out of same order. 1, 4,
Please tell
5.
him that we are waiting for him to come and address the court.
My lord.
Yes.
Up to 8, all these cases same all the same Dhamadi district lordship. Up to 8. Item number 8.
Item number 8,
Up to 1 to 8 lordship. 1 to 8.
1 to 8.
8 and also 11 also I think just of the same 10 and 11 also.
Yes, Mr. Puput, Talukdar.
Kanai not getting since 2007, my lord.
Ah.
Same order, my lord.
So we are waiting for Mr. Mozumdar to come. He is on length in some
এটা
court.
Google inform করে দিয়া যে কোর্টে টাইম বিং করে হইছে
কোর্টে মাতিছে বুলি কলো।
You call him, we are waiting. Yeah. 1 to 8.
1 to 8 lordship and 10 11 are also from the same way.
What about 9
9 is different. 9 is
Order has been complied with, my lord.
complied with? Item 9 is submitted by the council. That the directions contained in the order. This order dated 2009.
Yes, my lord. 209, 2016.
2016 passed the one of 2012 has been complied with. Accordingly, the
order to
matter
have order. The opposition
stands closed.
I am appearing for respondent of 4, my lord. I am appearing for respondent of 4, my lord.
The next are engaged for response.
4, my lord.
I love it.
10 11 lordship may taken up along with 8 lordship. So all Dhamadi matters.
10, 11.
Yes.
10, 11, along with 1 to 8.
ट्वेल्व टू टमाटो बेलेग टमाटो 13 है टमाटो सुजाता दो 11 तो all of पिक्चर लगो all of पिक्चर
Yes, how who's for 12?
12 lordships there are services awaited last thing. I have seen that order lordships newly implemented as 3 and 4 they have to take steps. Steps like 12 the services awaited.
As per office note. You are appearing for item.
12 lordships.
Item number 12, lordship.
Why have you not filed the amended post item?
Lordship, my senior is on lakes at
Don't
Kodumbar.
depend on your senior for
তুমি কবা
everything.
amended cost title help you লাগিব.
You should have the practice of going through the file. As per office note dated 2/9/2024, it is reflected that the amended post title for newly implemented respondent file not yet been submitted by council. MS Manso appears for further time. Accordingly, matter be listed after 2 weeks, enabling them to complete the process of filing the amended post title before the registry. Mr. 60 appears for response.
I am lordship in this case I am for the response number 3.
We are giving you 2 weeks. File the amended post title.
বুঝলে না বস্তু নাই গভর্নমেন্টে কথা আসলে
The last office and until for director of pension was
my lord here what happened I have talked with Ms. Deuri director of pension is not a right party it is a secretary lordship in the file is pending in the secretary of pension and grievance. So Deuri representing director is unable to get the instruction lordship he has to include the secretary lordship pension and department lordship. Because from our department lordship, we have already communicated to the pension and givers for approval of that pro rata pension. So they pension department they have to approve it. Then
No. You see the last, the order dated 28/8.
yes, B Deuri was supposed to.
So B. Deori has received some communication
Yes,
from the secondary department.
No, Lordship, BDUD represents Director of Pension, Lordship,
Okay,
but letter is directed to Secretary,
Pension
PNG
and-
Department,
So secretary-
ARTP and PG Department.
so that department has again written back to education department.
Yes, Lordship.
So he is not aware what instructions are there.
no, we have not, that we have not, we have already submitted that proposal to the parent department. Lordship.
When?
Lordship, I have given that instruction long back. Lordship.
Order dated 19/8.
Here,
Lordship, I have collected the name of the person, Lordship, that is Secretary to the Department of ARTP and PG, Lordship. He may be impleted, Lordship, as respondent number 8, Lordship.
you file application,
Application file for us.
file proper application. Yes, there is a communication dated 9/10/23 by which all the queries have been met and it was sent to the PG department, ARTP and PG department.
Yes, that is he want to implement. Lordship.
Who appears for the PG department?
Normally, government advocate appears for the pension department, but in contempt, my lord, BDUD appears for the director. He has included the director wrongly, Lordship. It should have been secretary, PPA, pension and given department.
Has, I don't see director,
Yes, because that was included, Lordship. Because that's a question. Huh? What is it? Now he wants to implement the secretary, Lordship. He has collected the name and he want to implement.
the registrar, Assam University, then
Yes, Mr. My friend.
Pritam Sekia, then
Pritam Sekia, earlier I am.
Mr. P. Jitung,
They were all retired, Lordship.
but there is no director pension.
Article
The Director of Pension was impleted, Lordship.
later on, Lordship.
Later on, Lordship.
No, it is not here. You have
Here,
filed
I filed post title, Lordship.
amended post title.
Yes, Lordship.
So amended post title has registrar, Assam University, commissioner,
Another,
secondary education, director, secondary. Subsequent to that again,
yes, Lordship. Another post title, Lordship.
Vikas Das.
Right.
So who represents Vikas Das?
Deuri,
no, because of BDUD.
But he-
Where is Mr. Deuri?
But that matter is pending before the secretary, not before the director. That is why Lordship now he want to implement the secretary, Lordship. Because that was wrongly implemented by my friend, Lordship.
Lordship, I may be allowed 2 weeks time, Lordship, to file proper application.
Mr. Das. Would like to increase the secretary
Lordship.
of
Secretary to the Government of Assam, Administrative Reforms, Training, Pension and Public Revival.
secretary to the government of Assam, administrative reform, training,
Pension.
pension and public development. Right. Response for party. Chisti appears for Mr. Chisti for
Yes, Lordship. And I am for respondent four lordship.
Forensic.
Forensic.
You're appearing for someone? Let's start with-
Obliged.
Okay, may pass over the matter for the time being.
Why? Contempt matter, order
Why,
complied,
sir?
not complied.
Lordship, yes, order dated 28/09/2021, where the order has not been complied. The relevant para is, Lordship, is paragraph 23, page 24, your Lordship. Paragraph 23, your Lordship. The Lordship has found.
Yes.
Yes, Lordship. Needless to say that the consequential relief that MD Noor Shahid Ali would be entitled by virtue of being provincialized from 01/01/2013 be given on current basis from the month of November 2021 and the area within a period of 6 months thereof, your Lordship.
So you have received current salary.
Oh, your Lordship.
And who's for the respondent here?
The three go, your Lordship.
So what has happened in this case, your lordship will kindly see the additional affidavit, your lordship. So there is an additional affidavit filed on 18/12/2023. Your lordship will kindly look here into your lordship's order at page, it will be running pages, it will be page 50.
Eighteen, 12.
No, but page 52. 24/8/2022. What has happened, my lord? There are two parts of this order. One part is that in regard to termination of the private respondent, and the second part was in regard to the payment of the salary and all which I am entitled. Now, so far the termination part is concerned, it has been stayed by the division bench. I will take your lordships to that order. But so far my payment and all, the division bench refused to interfere with. And in spite of not being interfered by the honorable division bench,
Who-
at page 52, your lordship, they say,
Who filed the appeal?
my lord, the private respondent as well as the state. That order your lordship will find.
Page 52.
No, there is another order also, my lord. At page 41. The relevant portion is page 43, one order. 41 is the appeal filed by the respondent whose services were terminated. And her termination was stayed, but the court did not interfere with the order of the.
No, but there is an interim order.
The interim order is only in regard to that stay of the termination that your lordship will find that order. I'm just pointing it out. Open the page.
Stay of the termination of the private respondent.
Yes, page 28 of the contempt application.
What is the stage of the appeals now?
Appeal, my lord, for one fitter because the private respondent is enjoying the stay and we have been tortured like anything. Take adjournment on one pretext or another. They don't want to, and the state said that they will file a review. The state did not prefer a review. Now they are saying that we'll argue if your lordship's order is there, that the state sought liberty to file a review. They did not file the review. Now they filed an additional affidavit in this contempt petition saying that they don't intend to file the review because they will pursue the matter on merit in the read appeal. That is one part of the aspect. Second, on the earlier whenever this matter came up, the submission was made that connected matters are the link matters are.
But once the appeal is pending,
appeal is pending only in regard to determination, not on my entitlement for my salary and all.
whatever it may be, but the judgment is challenged.
So that's why, my lord, we had made it on day one when they sought for termination. The court said that only in regard to the termination we are interfering, not on the other part.
Where is that order?
Well, that your lordship will find.
Right.
Page 29. Only this interim order is there in the writ appeal. Because we had appeared when they filed this petition, my lord, page 29 of the contempt petition.
29.
Yes, my lord. Order dated 7/12/2021.
29 is something else.
My lord, just a moment, my lord, just want. Page. 29 in the contempt petition, my lord. Yes. Yeah.
That is the edit.
No, yeah, it is not even-
28, you are referring to order dated 7/12.
Yes,
It's page number 28.
I'm sorry, my page they have marked. It's marked as.
Vishnu Khan.
No, the order does not say that the appeal is limited to,
No, you'll also see the last line.
that is the interim. Services of the appellant shall not be disturbed.
Yes, only in respect of the appellant, the services will not be. But my entitlement, because if your lordship looks into the main order, there are two parts to the order.
But ordinarily, there is an appeal pending. Pursue your remedies, you complete the appeal first.
My lord, that's why on the day one, my lord, the court has not stated the entire judgment. The court has only there are two parts to the judgment.
Know that, Mr. Kumar, that appeal is there.
Yes.
Ordinarily, the remedies in the appeal should be allowed to be concluded.
My lord, I
Not
cannot,
extending that there is no.
my lord, I cannot expect your lordship to remember what has transpired in the argument on 7/12/2021.
Of course.
If,
don't-
if there are the two parts, the honorable division bench on the which your lordship was a part. If your lordship have wanted to intend to stay the entire order, then your lordship will state it directly in the impugned
We
judgment order.
go by the, what is reflected in the order.
Yes, in the order, what it is said, my lord, the services of the appellant shall not be disturbed.
That's right. But it doesn't say that the appeal is directed only with regard to that. Rest of the matters, the court.
No, my lord, in the,
Inclined to hear it.
no, my lord, the other part, the court has not interfered, my lord, in the,
May not have, but the matter is pending.
my lord,
To accept your argument that no, the appeal will be limited only to the aspect of
well, then, my lord,
The-
your lordship will give me, this time I'll get a clarification again from the honorable division
you
bench.
need to.
Because they are not intent on hearing the appeal because they,
No,
they
no,
want to.
lordship.
No,
Last two occasions, my seniors in the Delhi lordship.
No,
so
only on the last occasion, only last occasion.
last two occasions, not single.
On the last, no, your
Last
lordship can
two occasion,
check it
lordship.
on, ask the
Last two
registry to check it online. Nowadays, we can't bluff. Only on the last occasion, my senior took
Even-
time that I was on Delhi in court number 1.
Even otherwise, we rely on what council say.
Yeah.
Why-
Your lordship.
Why check it?
But the last order is 8/8/2024. It says on the request of Mr. S. Hawk, Learned Counsel appearing for the appellant in writ appeal number 30/2021, hearing of this matter is adjourned least after 2 weeks. This is the last order of 8/8/21. I will go by the,
So unless, unless there is a clear direction that. the
No, my
appeal
lord,
is Only with regard to what part of the limited part.
my lord, I appreciate what has fallen from your lordship's mouth. My lord, only thing is that we'll get a clarification from the court that it is only in respect to the termination, or otherwise here is the appeal, and because we are in this corridors of this court from 2001, my lord. Now, so many years have passed, and still in spite of specific orders from the court on several occasions, my lord, we can't get any relief because the cabinet ministers and all are involved. And this was the case where first time a cabinet minister was asked to be present personally in a contempt case.
In this matter,
Yes, my lord. Earlier matters, my lord.
Not in this matter, also in.
Yes,
earlier-
the outcome of this matter.
Earlier occasion.
Ah.
all right. Heard Mr. P.D. Kaur, that is. I
So much.
am. And. A. Gogoi. Council appearing for the,
Respondents, lordship.
for all the, for all respondents.
Lordship.
Calendar.
It is an order
Where's the first
passed by the. The directions containing the judgment dated 28/9 passed in the PPC 1/4/2006 and the PPC 3654 of the 2014 and the PPC 6818 of and WPC 2475 of have not been complied with by the level of therefore the contemplation by submitted that the by the state judgment and order
You can't get caught.
present petitioner before the court was held to be entitled to provincialize with effect from 1/1/2013 be given on current basis from the month of November 2021 and the arrear
Yes,
be released within a period of and the arrear within a period of 6 months.
Superannuation consultant.
It submitted that this order that may
Letter of superannuation.
not complied with by the respondent. So,
Settled.
being agreed with this order, the state as well as the private respondent
And Melody, your lordship will also take note that in the meantime, during the pendency of all this litigation, on 28th of February 2022, the petitioner has been superannuated from his service.
private respondent, the petition before the Senate Secretary had preferred appeals which are pending, presently pending. In one of the appeals being appeal number 07 of 2021 by an order dated 7/12/2021. The petition pending while directing the release
How
to be
come
listed on the
Page is
later date,
different from the court.
also directed that the services of the appellant, namely the private respondent,
Have you
before the
compared
judge, shall not be disturbed.
That's way out of
Interim
the
order subsists till the
Melanie page.
eternal sitting of the further reference to. Where is that order by which they say they file an appeal?
Oh, yes,
Review
yes, ma'am.
frequently.
At page 50 of the 52, I think.
Page 50.
52. Give me the.
The written bit by
Can I
another
find it?
order dated 24th May 2020. Last date, dated 07. And people also recorded submissions of the agent state that states sought liberty file a review the judgment passed by the presently appealed. So, the interim orders were directed
Your lordship,
more, however, submitted that in the meantime, when did he superannuate?
on 28 to 2022, 28th of February 2022,
22,
28.
28 to 2022,
Yes, ma'am.
with effect from 28 to 2023. The petitioner is court at the meantime.
Your lordship may also take note of paragraph 8 of the affidavit filed in this contempt petition by the state government.
He therefore submitted that the matter should be decided and the interim protection given by the writ appellate court is only been release of the private. Mr. K. Gugoi Ladan, counsel hearing for the response that there is no clear indication in the order to that effect. For the matter is pending for the appellate court and an interim order subsists. petition be deferred, enabling the parties to approach the writ
Lordship,
court.
Lordship.
Writ be deferred. Having heard the council, considering the various orders passed by the writ court, as well as the interim order, we see that there is no clear direction that the writ appeal deferred be restricted to the extent of there is no clear direction that the writ appeal will be decided on the aspect of the release of the release from service of the private respondents like the writ appeal. It is also seen that the interim order subsists till date. Under such circumstances, and the fitness of things is quoted to be 4 weeks.
Well, may I pray, I'll take one chance before the vacation on 26th of
The
September.
parties are at liberty to approach the petition date for an early disposal of the
Lordship,
pending. Let the matter be listed again.
On 27th, we'll take one day, one chance before the vacation, madam.
27,
Yes, madam, of September.
27th of September.
One chance we'll take.
Oblige, Lordship.
We are blessed.
Yes,
Wait,
Mr.
wait,
I
The
think-
service report was awaited, my lord, on
No,
this one.
for respondent 4, I had filed my Okalma today lawsuit
Oh.
for the commissioner, secretary lawsuit education. So I need some time to get the instruction from the secretary lawsuit. Only
Respondent
3 to 30
number,
goals.
respondent number
4,
4.
4 I have just, today I am filing.
Who's for 3?
3 the finance lawsuit, finance, ne? Finance, secretary.
Kalia.
Okalma file koi nahi.
Then who's for 1 and 2?
1 and 2 lawsuit, they were implemented lawsuit by the new incumbent lawsuit. So today I am filing for on behalf of the secretary lawsuit. Earlier, it is already retired lawsuit.
So in their place,
In their place lawsuit, Narayan Kaur has been implemented as a secretary. In place of restaurant number 1. Monish Thakur আছে না?
in respect of respondent number 4,
Yes, 4.
which submits that he received instructions that he
Now I'm filing Okalma today
by
lawsuit.
his power represent respondent 4, praise for some time to complete his instructions. Then for number 3,
Lordship, I'm not appearing for number 3, I'm appearing for respondent number 5, Lordship.
who's for 3?
He was the earlier commissioner secretary, Lordship, I am not aware, Lordship, he has.
He is no longer holding the post.
No longer.
Number 5 has been included in place of,
In place of respondent number 3, Lordship.
You are appearing for 5.
Yes, Lordship.
So 5 is, you are already represented.
Yes, Lordship.
So service is complete, I think.
Now only 3 is not here.
But he's no longer.
He is no longer holding the post.
in place of 3, my lord.
You appear for 3 also. Mr. Chaliha is- represents respondent number 3 and respondent number 5. He was the former
Yes.
finance
Lordship,
secretary.
yes.
Here on his case. Since the services are complete now, the matter be listed for necessary orders on, tell us how much time you,
After 2 weeks, lawsuit,
23rd,
2 weeks.
23rd of September. Subject to availability of Mr. Nair.
Yes, that is why he is searching for it. Yes.
Deeply obliged.
Yes, Mr. Manan.
This matter, the order of this honorable court is at page 8. Earlier, your lordship, there are some directions by the honorable court to comply with these, but I don't know whether they have, till then I have no instructions. that has
Take it
not
out
been-
of sometimes it's a PK Bora lawsuit, he is on Lex Kotma to he is appearing lawsuit.
This order dated 2001.
This is an order passed by 20/01/23. there are some other orders subsequently in this contempt petition where this is basically, I'll just take your lordship for a moment in page 11. For a moment, page 11, your lordship. I'll just take your lordship to para 5 onwards. Thereafter, I'll just read this so that your lordship will get a catch of what exactly the matter is. Thereafter, an advertisement was issued on so and so, whereby the applications were invited from persons appointed during the period from so and so as to verify their records. The screening committee was also constituted to examine the claim of the irregular and illegally appointed teachers. The petitioner appeared before the said screening committee. Screening process was completed and thereafter 3 lists were prepared by the department, which includes firstly the teachers who have received salary at some point of time having JBT, DEL, the next list was of those teachers who received salary at some point of time but were not having JBT. The third list was prepared consisting those teachers who had neither received salaries nor qualified for training or praise. In respect of Tinsukia district, a list of 209 teachers pertaining to list 2 was published. The present petitioners claim to belong in the category of the second list of Tinsukia. Mr. Swenson claims that had that list been properly prepared, the petitioner's name could have found place in the said list in as many as 35 names of 35 numbers of persons were repeated in the list. In the meantime, the petitioner 2 and 3 have been appointed on the basis of such list. The petitioner claimed that had this list been properly prepared, the petitioner could have been accommodated in as much as the petitioners 2 and 3 has already been appointed in the basis of such list. The facts that has narrated herein above are not in dispute. The second list 2, which annexed as Annexure K in additional affidavit filed by the petitioner, reflects 209 persons who are enlisted against Tinsukia district against list 2, that is the list of teachers who received salary at some point of time but were not having JBT, DEL, ed. The petitioner herein claimed to belong to the same category and they also claim that they received salary at some point of time. The list further discloses that names enlisted in serial numbers 1 to 15, 17 to 21, 24 to 36, 40 to 42 pertaining to the Tinsukia district were again repeated in the same list against serial number so and so, so and so, and so and so. If that be so, and as agreed by Mr. So and so, Standing Council for the Secondary Education of the Assam, a reconsideration of the said select list is required. In the meantime, the petitioners have also filed representations before the authorities raising their grievance by bringing into notice the respondent authorities the alleged anomalies in the second list pertaining to Tinsukia district. Now the court's decision. That being so, and as agreed by Land Council for the parties, this court is of the considered opinion that the writ petition can be disposed of with a direction to the Secretary to the Government of Assam, Department of School Education, to look into the alleged anomalies of the repetition of name, and if it is found that the names of the persons are repeated, the list in question relating to Tinsukia district be recasted, and if after recasting of the names, the petitioner come within the zone of consideration within the list of 209 in Tinsukia district, they may be appointed in terms and policy of the government in this regard. Now, these two parts have not been done. Neither the verification is done, nor the recasting is done. This matter is continuing like this. And I think your lordship's orders are there to do the needful, your lord.
PK Bora Lordship, he earlier appeared Lordship.
Please inform me.
Here what one speaking order has issued on 27/6/24 is here Lordship may can be period. Copy 9 में आता है copy दिलो मुझको बताइए even इसे मुंह नहीं कैसे हो double entry one second
Yes.
এই নামবোৰ তাৰমানে এন্ট্ৰি ডাবল
This is for what?
This is the speaking order issued by the secretary. I think just
So you are saying that
the verification part has been done. That is what I have seen, Lordship. It is elementary in the second class.
it has been done. Are you aware of this order?
No, your lord, I have not been.
Just have a look at the order.
Hey, But they have recasted it.
কপি এটা মই দি আছো মোক এটাই কপি থৈ গৈছে
হ'ব, মই এনেই চাই লওঁ। No, this is not what they have came to a ground is that the decision is that in compliance to honorable court's order and after careful examination of all record and considering the fact that the petitioners were not extending any service in the respective schools since 1994, they claim to be accommodated as tutor does not stand ground and hence this is not the case. The case is with regard to illegal and irregular teachers who were as on the direction of the honorable division bench that I have, that is there at para 4. It was done to do an enquiry. In enquiry, 209 names were found. Out of the 209 names in the second list, which is an admitted fact in the order itself. This is not a question of tutor or something, appointment or something. This is with regard to whether there were only 3 points are there, whether at one point of time they have received salary or not. They were appointed within that period or not. That is the only requirement. Where is the question of this second part comes? I don't know how, what this, why this order has been.
Yes, Mr. Bora.
Regarding this, my lord, on earlier occasion, I was directed to bring instruction, my lord, regarding repetition of the name of the petitioners. My lord, that instruction I have not.
repetition double entry.
My lord, this is not regarding the only Rotan Hazarika and Lohit Gogoi. Two names repetition is.
No, they have been appointed. Other,
my lord,
They've been appointed twice.
no, in the list, their name has been repeated.
No, they were also petitioners. They were subsequently appointed. This is
Other thing is that,
the 35 names are repeated, that is already annexed in the annexure. That's not disputed. So repetition is there. After the repetition goes, who else are supposed to come in the list? If the recasted list comes, then I am within the consideration. This can be disposed of. Where is that recasted?
Other thing is that since 1994, they are not in service, madam.
That is not the case.
See the order,
My
of
lord,
the court, page number 12. It's a very specific order. And this is a consent order. The consent order, have you seen paragraph 13?
Well, one last more chance maybe even my lord, regarding recasting, my lord, repetition of name. If I will fail to bring that instruction, my lord may pass order.
Because your lordship first line in the page 12, this annexure is an admitted fact. Because I have annexed this, that two names are repeated. So they have to
How
recast
much
it.
time do you
Whether
look?
10 days time may be granted, my lord. If I will fail, my lord, lordship may pass order.
Yes, Mr. Manan, we give him 10 days further time. Mr. Y. Manan, Y. Submit satisfied of the order dated 2001 last week. WPC number 6675 2016 has not been complied with. In the said order, the following directive was issued. Court paraphrase. Mr. Bora, the council representing
Respondent number 1.
submit that in sort for instruction. He renewed his prayer for further time. Complete his instruction. 10 days further time. Considering specific direction passed by High Court and bench by the order dated passed. It is necessary for this court to decide whether, in order to decide this matter, necessary this court have the instruction of the study council this direction. And if so, what consequential orders, if any, are passed by the court. So such circumstance, we defer the matter for further 10 days. And if Mr. Bora is required, the matter is still on 23rd of September.
Lordship may specify that there were two directions. One is to verify whether there are those anomalies are there and
Yeah.
and the recast.
We have quoted the entire paragraph. Let the matter be taken. 23rd
Must
of September.
Obligement.
Yes. Mr. Mazumdar,
A little handicap today, my lord. The two persons that I represent, my lord, either one of them is expired, one of them is retired.
so
So
you
as
have
of today, what I
you
can
have
do,
a copy of the petition.
my lord,
There was an order earlier passed on 3/10/2019.
I apologize, my lord, that order copy is not with me. All these cases were taken up in a batch together, and
So
then
then
they
it
were
was segregated.
in 2021.
Invite it
Uh,
in
uh,
the second batch.
Huh?
This is the contempt.
Contempt order. My lord, the contempt cases usually have only one
Yes.
file.
Anyone has this order? 3/10/19? 3/10/2019, you have.
My lord, I tried but to get it download, my lord, but.
Yes, I'll have it, my lord. Lordship will give me
Network
just
problem.
a little time, my lord.
310.
I'll have it. Three ten
310,
31090. You would have
2019.
কোন sir?
নুখুলে নুখুলে
আপোনালোকৰ slow.
পাইছা
It's up to you.
legal
Legal. Legal. Thank you.
please
The court has passed order today on in WPC and in other link cases. Copy of the same may be placed in the record copy. Order to name.
same order
You can order.
6553
3/10/2019.
Yes. That 1 month salary. That order just before the puja break that
There
was
was
given.
a director filed the complaint
Yes.
happened after 5 years. We are back to eve of puja.
All these cases were taken up together. This order was not.
So did you undertake the exercise or not? You have no instruction. Is the PA.
My lord, actually, since it has come out for 2021, just yesterday I went through the above files. So if you will give me a week, my lord, I'll try to find out. So far as I remember, the matter was listed hereafter several times, but the orders are not here. It was in the parent file which was leading the case. The orders were placed only on that file. I'll trace out all those orders. If I remember correctly, this was not required to be complied with because it was not required to be complied with. It's a low issue. Parent order
Which is the parent matter?
need not be complied with.
Lead case.
Yes, it is there in the list. বিদ্যুৎ জ্যোতি বৰা নাছিলে এইটো অৰ্ডাৰটো হৈ আছিলে হিৰণ্য ভেও নহয় কবিতা সেনাপতি নহয় হেৰি নাই বুলি নিগ্নটো কমপ্লেইন আমি এটা লৈছিলো নহয় কনফাৰ্ম
Mr.
I remember, my lord.
Learned counsel representing the respondent submits that since the earlier orders passed by the court, pursuant to the earlier orders passed by the court, the department may have undertaken certain steps in compliance of the order. However, not posted with the specific instructions with regard. It prays for a week's time.
এখানে weeks time.
Let the matter be listed after 1 week.
Yes, 1 week.
On 20. The day I brought here. Sorry, contemplated. This will cover, this order will cover.
All the cases, Lordships, 1, 2.
Maybe hard, my lord. Already director send a letter to the commissioner.
No, but the same order is available.
Yes, yes.
No, but director send a proposal for sanction
Huh.
regarding the petitioner's salary.
Two number there.
সেইকেইটাত হেৰি আহিব লাগিব নহয় মানুহকেইটাতো ইমপ্লিট হোৱা নাই
ইমপ্লিট হোৱা নাই এইটো মৰিয়ে থাকিল
মোৰতো কমিশ্যনাৰ মৰিলে আপুনি যিটো কমিশ্যনাৰ কথা কৈ
Written on 2017.
কাক দি দিলে কম্পাই কৰাব
Affidavit filed by the director, my lord.
Yes.
No, that was written in the year 2017, my lord, 18 July.
কেছটোৰ নাম কি সেইটো অৰুণাচল গোটেইকেইটাৰে আইন দিম বাৰু
An amount of rupees 346,063.
3 লাখ 30 লাখ টকা কিমান এইটো চব
This is only for area.
Area up to 2016, my lord. 2017, 2016.
Same submission, no instruction.
at this moment my lord I have none because I cannot represent the present secretary general.
No, we are not asking about who you represent or not. You represent the department, essentially.
Yes,
Yes, that is
So
there.
therefore, you get the instruction from the department.
all the cases
There is an order passed by the court, it has to be complied with.
There, my lord, thereafter, my lord, there is an order of 27/11/2020. There are several orders passed, my lord. These are not in these files. I'll have everything settled out, my lord. Lordship will give me a week's time. I'll have it settled. At least the stand of the department I'll have on record.
Let it be on, we are giving you 20 or you want, we'll give you on 23rd,
My lord.
23rd of September.
Oh, my
All these matters.
September 25th, my lord.
25th,
My lord.
25th of September. 1 to 8.
1 to 7.
1 to
7 and
7.
and 10 and 11.
10 and 11 is? No, 10 is disposed of.
No, 9 is disposed of, Lordship.
Sorry, 9 is disposed.
10?
10 and 11 same letter এইবিলাক
আগতে মাতি দিছে নেকি?
না একেলগে
This will be 1 to 8, 10 and 11.
yes yes
1 to 8 নে 1 to 7?
1 to 8
1
to
to
8 to 11
Note correct. 25th of September.
Obliged.
আমার 15 টাকা হতো না আমার
Yes.
we have to
These are the notification of extension were challenged, those matters, series Lordship. Lordship, recently the respondent CBIC has posted on social media that today there is a GST council scheduled, 9th of September. All modalities of the reliefs given in the budget announcement shall be released today itself. I suppose most of the cases shall get solved within 10 days if the notifications are out today, Lordship. But modalities have to be seen before withdrawal, Lordship. Whether it has to be withdrawn or to set aside or whatsoever.
There was somebody asking for.
Now, meanwhile, we have prepared lists of our cases. We will furnish to Mr. Kyal. You can.
You were supposed to do it by today.
So we have already prepared it. Okay, we will furnish it.
Lordship, another thing, the budget, the gazette notification which says that section 114 to 157 shall come into force on such date as the central government may by notification in the official gazette account. And today is a council meeting will be held. Probably notification by tomorrow notification will be out.
The text granting the reliefs to us have been notified, Lordship, but it has not been made applicable. It has not commenced as yet. Commencement has
There's
to
one
be
more
notified,
thing
Lordship.
that center state has yet to make an amendment to this extent.
So how much time do you require?
Lordship, maybe next week, probably notification will be out by today itself. On 17 maybe fixed.
17.
Lordship, actually a longer date may be given because center notification itself will not suffice. Even the state legislature has to pass a similar amendment. So maybe 2 or 3 weeks might suffice.
We'll keep it on 26th. 26th of September.
Obliged.
Learned councils for the parties.
Lordship, item number 61 is not strictly covered by the section 16 amendment, my lordship. It is related to the other issues, my lord.
We have requested the councils to give a list, furnish a list of the matters along with the subject, the prayers you have made. You furnish a copy to Mr. Kyal, who is the counsel for the GST, and then the matters which are not covered by this notification will segregate.
Noted, my lordship. Deeply obliged.
On the next date. But before that, within 2 days, you furnish all the list to the to Mr. Kyal, or you furnish it to the court master by way of.
Surely, my lordship. Surely, my lordship. We'll do that, lordship. Deeply obliged.
The councils submit that the GST council meeting is fixed on 9th of September 2024. And there is every likelihood that the meeting will be held today, is 9th of September, and thereafter the necessary notifications will be issued in that regard. The councils therefore submit that both the matters, that all these matters be listed after 2 weeks. So meanwhile, the councils for the commissioners are directed to compile a list of the matters and the challenges made respect of each of the matters and furnish the same to the court master and a copy to the standing council SCKL as well as to each of the council of the state PSC. The state council will act as the nodal council and segregate the matters which are not likely to be covered by the
Finance Act 2024.
Finance Act
2024.
2024. The amendments brought to the Finance Act 2024.
Lordship.
The compilation be completed before the next date fix, which is what date did we give you? 26.
26.
Of September.
Lordship, interim to continue.
Interim
Order.
orders passed in the matters. Interim orders were passed. It continued.
Lordship. Obliged.
Lordship, up to item 63.
Item 60, up to item. Now, the councils are requested to comply with this order and
Lordship.
prepare the list.
Okay.
May it please your lordship. It is a regular bail application. Case pertains to robbery, my lord. 34 lakhs of rupees was in a bag. The bag was snatched, my lord. 5 lakhs and 50,000 rupees were recovered from my possession. Another 21 lakhs rupees were recovered from the possession of 3 other persons. Now, I've been in custody for 72 days. And one development was there, my lord, when I was arrested. I was shot at my kneecap, my lord. And I was in the hospital. I was hospitalized, my lord. So at this stage, my lord, suppose there will be incriminating materials, my lord, but length of detention and considering the fact that, my lord, I was shot at, maimed for life, my lord, that may be taken as a mitigating factor while deciding the bail.
Yes.
Lordship, however, if you look into the FIR, Lordship, the total loot amount is 34 lakhs 51,816, Lordship, out of which recovery amount is 21 lakhs 52,000. And from this person, the accused person, 5 lakhs 50,000 has been recovered, Lordship.
What is the stage of the investigation?
So
If it
two
recovered,
persons,
then
two persons are already absconding, Lordship. They need to be arrested, Lordship.
so what is the need for keeping him under detention? From him, whatever you have to recover, you have recovered.
But the other
What is the need for
total amount has not been recovered yet, Lordship. It is 34. Only 21 lakhs 52,000 has been recovered, Lordship. 21 lakhs, my lord, and another 5 lakhs. 21 lakhs from 3 persons and 5 lakhs from my total recovery is, Lordship, there only.
so whether his further detention is necessary?
Because it is 120B, Lordship, other persons are also involved. These are the persons and other co-accused also named him, Lordship. Other co-accused.
It's okay, you file your charge sheet, complete and file for that.
Other persons are there, Lordship. This is the organized crime, Lordship. It is a grievous, Lordship. The Nesar is.
What does your DP say in respect of the
His
investigation being continued?
His involvement is there, and moreover, 2 persons are yet to be arrested, Lordship, and the amount is also, total amount is also not recovered. So investigation is going on. The 395 is there, Lordship. It's a dacoity, Lordship.
Okay, but it is at this stage of investigation. You tell us when the charge sheet will be filed, when the investigation will be complete.
The statutory 90 days are there, Lordship.
What is the stage of investigation? What is the last date of entry?
Last entry is, Lordship, 36, 2024.
You get updated. How much quality you require? From where is it from?
Pokrajhar.
On 7/7 was not on the city Lordship, forwarding.
7/7, I was re-forwarded after
Re-forwarded.
being discharged from the hospital.
Mhm.
I was arrested and shot at on 30th of June.
There is a mandatory period of 90 days.
90 days, my
Lordship,
lord.
90
I'm not pressing on that issue, my lord. I'm just saying that, my lord, considering the fact that I was shot at, I have been maimed for life, my lord. Whatever my implication is there, my lord. I'll
What
be,
is that? What,
no, that as a mitigating factor, your lordship can take that as a mitigating
how-
factor.
do you require medical? Do you require any assistance for moving about? I don't know.
My lord, I have been shot at the kneecap, my lord. I will not be able to walk, my lord. Properly, I will be on my entire life. I will be on
You
crutches. my
get a
lord.
medical certificate on that.
That is there on record, my lord.
Where is that?
My lord will find at page 16.
This is not a medical certificate.
Not, my lord, the report of the IO that I have been shot at my left knee, my lord, and then I was
Right.
hospitalized.
The submission that you are making that you are maimed and you'll not be able to walk for life requires a medical certificate.
Lordship can take judicial notice of the fact, my lord, that since there is a shot at bullet wound at the kneecap, my lord.
When do you complete 90 days?
90 days will be completed, my lord. Today is 72 days, but 18 will be, my lord.
18 days.
18 more days, my lord, will be 27.
You'll have it on 27.
Few more days, my lord. Prior to that, my lord.
27. Or you want a date earlier?
Earlier date, my lord.
23rd. Based on 23rd. When we update. Praise God calling for updated. The update. Will you be able to get it by 23rd? Updated city.
I will try, Lordship. It will be difficult
2 weeks, my lord. 2 weeks.
from
Should be
Kokrajhar.
Should be possible, my lord, from Kokrajhar.
Work for it. Call for updated city in the meantime,
Lordship.
along with any other medical reports.
We have to send back the report, CD, Lordship.
You do it today.
Lordship, I will.
Call
send.
it.
Lordship.
List on 23rd.
27.
Mr.
Yes, Nawaz, my lord.
S. Nawaz. It is.
I'm deeply obliged, my lord.
These are what matters? VAT.
These are VAT and GST combined. Basically, there's a challenge to the Assam Industries Tax Reimbursement of Eligible Units Scheme 2017 that is under challenge. That they are getting benefit under the 2017 scheme,
Yes.
and in 2020 December
You will be addressing WPC 1834.
2068.
2066. 2068.
Yes, ma'am. 2068 of 2021.
2068.
The second.
Yes.
They have challenged page 217. The notification dated 30th December 2020. If Lordship is please look at their prayers. Their prayers, Lordship will find at page 41.
270.
Lordship will kindly come to page 41, 42. They have challenged.
Sorry, page number?
42, 42. they have only single prayer. There is no interim prayer also. So they have challenged, they have prayed before this honorable court to issue a writ in the nature of certiorari to declare the impugn Assam Industries Tax Reimbursement of Eligible Units Amendment Scheme 2020 as illegal and consequently strike down the same. That lordship will find it page 217. 30th December, these dates are important. 30th December 2020. Whereas it is expedient to amend the Assam Industries Tax Reimbursement for Eligible Units Scheme 2017, the Governor of Assam is pleased to amend the said scheme hereinafter referred to as the principal scheme. That savings clause, notwithstanding the omission of the provision of the said scheme as mentioned in clause 2 above, all orders issued thereunder by the Finance Taxation Department for extension period of eligibility shall be deemed to have been validly issued as if this scheme has not been amended. Further, all pending applications on which the order for extension of period of eligibility has not been passed shall be deemed to have been rejected. So they are basically aggrieved by this provision. In fact, the whole notification. So that is the basic effective part of this notification of 30th December 2020, back end of the year. Now, the basic facts of their case is that, lordship, they have, there is a, the writ petition is a manufacturing unit with the production of some sacks and bags. And they are entitled for some benefits under the 2008 Industrial Policy of Assam. So they obtained the eligibility certificate and an entitlement certificate.
Yes.
Page 158.
Yes.
So on 9/11/2015, this eligibility certificate for new units was issued. Certified that MS Lalit Poly UIF LLP, bearing number so and so, dated so and so, is granted eligibility certificate for claiming incentive under Industrial Policy of Assam 2008 and for claiming exemption of tax under the Assam Industries Taxes Exemption Scheme 2009. So the particulars about the industry, the relevant portion here will be page 160. This certificate was issued on 9th of November 2015 with a retrospective effect. Period of validity, serial number 9, incentives approved. Name of incentive, VAT exemption. With effect from 21/9/2013 to 29/2020, 7 years, subject to maximum of 100% of the eligible fixed capital investment for the unit. The figure is quoted here, and power subsidy, which is not relevant for our purpose, that was up to 2018, 5 years period. So they got the approval for getting tax VAT exemption for the period of 7 years under the industrial policy from 2013 to 2020, September, 7 years. And on the basis of this was issued by the industry MD of AIDC under the industry department. Now, subsequent thereto, under the scheme, a certificate of entitlement was also to be issued at page 161. This is to certify the unit in the name of so and so under the Assam Value Added Tax Act 2003 holding eligibility certificate 4/11/2015 is entitled for exemption of tax in accordance with the provisions of Assam Industries Tax Exemption Scheme 2009 the dealer is entitled for exemption of tax to the extent of so and so amount within a period of 21/9/2013 to 29/2013 in respect of the sale of the finished products so and so. It was issued on 27/2016 before the GST regime during the time when the VAT was in force. So the period was very clearly specified that it is up to 28 September 2020. And Lordship will also mark that they have already started their production sometime in the year 2013. In their reputation, they have stated that part. The commencement date. Yes, page 13, paragraph 6. Lordship will kindly find the last 2, 3, 4 lines. The petitioner made total investment of 14 lakhs, 14 crores or something. Yes, in the industrial unit for land, site development, building, electrical equipment, and the commercial production of the said new industrial unit commenced on 21st of September 2013. And in page 159 also, that is reflected in the eligibility certificate, serial number 3 at the top of the page. Date of commencement of commercial production service 21/9/2013. So what I am trying to say before going to the 2017 and 2020, so he has invested money, set up the unit and started the production in 2013 itself on the basis of the industrial policy of 2009 and the rules and scheme and of 2008 and 9. So whatever promises, whatever commitment the government gave under the industrial policy of 2008, followed by the scheme of 2009, it was for 7 years period. So that 7 years period up to September 21st, 2020, he has got it. Once the new, so he has invested and changed his position on the basis of the promise. If at all it is a promise, he has obtained everything. There is no dispute on that. Till this position, the facts are undisputed. Now in 2017, after the GST came, the government of Assam, although there is no obligation, and the GST Council also left everything to the discretion and wisdom of the state government, whether if they want to give any benefit to the existing units who were entitled for any tax exemption under the VAT regime, value-added tax regime, because the whole regime has been changed from 1st June 2017. So that option was given. So Assam government was under no compulsion that we have to continue. If the VAT is withdrawn, there was no compulsion under the GST Council. That is a statutory body. I can show some of the documents from where it is very clearly said. But Assam government was given the discretion. If they want to continue, then they can continue. So the new scheme was brought. Assam government, on its wisdom, thought that we have to give some support. So page 165. Scheme for reimbursement of tax paid under Assam Goods and Services Act 2017 by an eligible unit located in the state of Assam. So this scheme was brought, and next page 166, third column, whereas the existing system of tax exemption is not compatible with GST regime, and hence the GST Council, constituted under Article 279A of the Constitution of India, in its meeting held on 30th September 2016, decided that all entities exempted from payment of indirect taxes under any existing tax incentive shall have to pay tax in the GST regime, and in case the central or state government decides to continue any existing exemption incentive deferral scheme, then it shall be administered by way of reimbursement mechanism through the budgetary route support of such units. So we have incorporated that. So we can still do it. That option is given, but it is not mandatory because there are several resolutions and guidelines of the GST Council. They left everything to the central government or the state government for this purpose. However, the state government in its wisdom deemed it proper that we can give it to the existing ones also because they were given tax exemption for a period of 7 years, which was not over or expired in 2017. Then, last paragraph of page 166. And whereas in order to stimulate industrial activity, attract investment in the state, generate employment opportunities and bring about socio-economic development in the state of Assam, and as a measure of goodwill, and to honor the said commitment of the government of Assam to provide reimbursement of tax paid under the Assam Goods and Services Tax 2017 to all the eligible existing units operating in the state under the Industrial and Investment Policy of Assam 2008 or under Industrial and Investment Policy of 2014, covered by earlier schemes or special notifications to the extent of unavailed monetary incentives and for residual or unexpired time limit for which each of the unit is eligible. B, to the eligible new units or expansion units which commences their commercial production operation during the period commencing from 1st July 2017 to 31st December 2000. That they are not entered. They do not come under this B. The governor of Assam is here.
They fall under A.
They fall under A. The governor of Assam is hereby pleased to notify the Assam Industries Tax Reimbursement for Eligible Units Scheme 2017, hereinafter referred to as the reimbursement scheme for granting reimbursement of taxes to eligible units in the manner hereinafter appearing. So now, what I am trying to emphasize is that one of their argument is that they have changed the position in terms of a promise. Here, they have changed the position in terms of the promise or the incentive which was shown to be there under the 2008 as well as 2009 scheme of the state government to set up new industries, which they have done, and under that scheme, they are entitled for tax exemption for 7 years from the date of commencement of the production, commercial production, which they have got up to 2020 September. So with the coming of this exemption, they are not investing anything additional. No extra efforts has been done. In other words, they have not changed any of their position. Whatever was accruing from the earlier regime, that would have come to an end with the bringing out of the GST scheme in 2017. But however, this scheme allowed them to avail the benefit for 7 more years. 7 more years commencing from 2013. That means up to 2020. That means 3 years additional. That is one part of my arguments, but I am gradually developing it. Now coming to the scope of operation, clause 3, page 168. 1. The reimbursement scheme shall be applicable to the existing eligible units which are eligible for full or partial tax exemption under the following policies or earlier schemes or notifications, namely the Assam Industries Tax Exemption Scheme of 2009, framed pursuant to the Industrial and Investment Policy of Assam 2008, or notification issued by the Finance Taxation Department granting customized tax incentives under the said policy of 2008. So they got the eligibility as well as the entitlement certificate under this. So they are eligible under 1A. The Assam Industries Tax Exemption Scheme 2008, that they are not covered. 2. The reimbursement scheme shall further be applicable to new units or expansion units which commence their commercial production operation during the period from the first day of July 2017 to 31st December 2022 in terms of the eligibility criteria of industrial and investment policy of 2014. We are not concerned about all this. So 3(1)(a) covers their case. Now coming to 5, page 172. Limitations and conditions of earlier schemes and policies to apply. Notwithstanding the rescinding of the earlier schemes, the eligibility criteria, limitations, conditions, scale of tax exemption and prohibition and restrictions under the relevant industrial policy and under the earlier scheme issued by Finance Taxation Department as they existed immediately before 1st July 2017 would continue to be applicable to the reimbursement scheme except to the extent expressly been modified by this scheme. So they will be entitled. So now, this is the basic factual position as well as the law which is prevailing. So we wanted to give them the exemption as per the earlier benefit. Now in 2020 December, we issued the modification or amendment and rejected all the applications for the additional period. In fact, we have revoked the scheme in 2020 December, which was given in 2017, which I have just placed. Their basic ground for challenge, what they have submitted, I'll deal with each of the arguments by placing our affidavit as well as the relevant law, which will be very crucial for the purpose of adjudication of this case. So according to them, it is an arbitrary exercise of power. Number 2, they are saying that there is violation of Article 14 and the doctrine of promissory estoppel. 3, amendment cannot take place the right of industries for the benefits under the scheme without reasons while giving it to others. 4, according to them, proviso 4(1) of the scheme provides for extension on genuine grounds. As such, amendment of the scheme by notification dated 30/12/2020 without a valid reason should not have been done. And favoritism done to some industries by giving extension and rejecting others by the amendment amount to meting out discriminatory treatment to similar industries. So according to them, basically their ground of challenge is that it is an arbitrary exercise of power. There is a discrimination between some industries who are getting benefits under the 2017 scheme beyond December 2020. Third, that there is a violation of the doctrine of the principle of promissory estoppel and vis-a-vis violation of the mandate of Article 14. These are the basic grounds. Now, we have to see what was the promise, even if there was a promise on behalf of the state of Assam to the writ petitioner to establish this unit, that he will get tax exemptions for a period of 7 years and power exemption for a period of 5 years. On the basis of that promise, initiated with the industrial policy of 2008 and industrial scheme of 2009, he started the commercial production in September 2013 and he availed full 7 years benefit up to September 2020. Where is the question of violation of the principle of promissory estoppel? We promised 7 years. We could have stopped it in 2017 itself. Because if there is a change of law, the law is well settled by the Honorable Supreme Court. I'll place all the judgments, Lordship, starting from CG, Kasinka, everything. so far as his case is concerned, this particular writ petitioner, he has availed full benefit of the promise enunciated or conceived on the basis of 2008 policy and 2009 scheme. There is no violation of the principle of doctrine of promissory estoppel. So far as the writ petitioner of WPC 2068/2021 is concerned. According to him, there is a discrimination with other industries. For that, he has annexed Annexure 8, page 216.
So, according to you, as per the policy, it's for benefit for 7 years.
7 years.
After 2017,
Under the scheme, he got it for full 7 years.
brought another scheme for extending the benefit
Yes,
for the balance number of years.
balance here.
So in a sense, there was no violation of.
No violation of the principle. We have not withdrawn our promise so far as his particular individual facts are concerned.
Yes.
Now, this benefit, one is the tax exemption, one is the period is concerned, the other part is that he can avail a maximum of a particular amount. He can take the benefit. He has not exhausted that particular quantum of tax exemption. In that situation, the scheme allows that if he gives a genuine ground that he could not avail full benefit of the financial benefit, then there is a scope for extension. That is page 168. Under the 2017 scheme, it was not under the 8 or 9. So, determination of the amount reimbursable. Subject to other provisions, the amount reimbursable under this scheme to the eligible units shall be as below. For existing unit eligible under the Industrial and Investment Policy of Assam 2008, where an existing eligible unit is holder or will be holder of certificate of entitlement in due course as per the terms of the Assam Industries Tax Exemption Scheme 2009, frame pursuant to the Industrial and Investment Policy of Assam 2008, or an existing eligible mega unit to which the customized tax incentive has been granted by special notification issued by the Finance Taxation Department pursuant to the Industrial and Investment Policy of Assam 2008, shall in respect of intra-state supplies made within the state be entitled to reimbursement of 100% of the state tax as GST paid to debit in the electronic cash ledger account maintained by the unit in terms of subsection 1 of section 949 of the GST Act 2017, and after utilization of the input tax credit of the state tax and the integrated tax available until the amount of tax reimbursement exceeds the unavailed quantum of the monetary ceiling or till the expiry of the residual period of eligibility, whichever is earlier. Provided that if an existing eligible units, including a mega unit to which the customized tax incentive have been granted, is unable to utilize or avail the full amount of monetary ceiling within the specified period of exemption, it may make an application to the Finance Taxation Department for extension of the period of eligibility. Upon such examination of such an application, if the Finance Department is satisfied that the unit could not have achieved the full quantum of the monetary ceiling due to some genuine reasons,
and in order to sustain the industrial unit, it is necessary to extend such time limit. It may, by an order, extend such time limit by further period not exceeding 5 years. So suppose his period is over and he could not avail the full benefit of the total quantum under this scheme. It was not there in the earlier scheme under which he established the unit. That means 2008 policy as well as 9 scheme. So in the new scheme of 2017, this additional clause is inserted where if they could not avail the full financial benefit regarding the quantum of monetary ceiling for some genuine reasons, then finance department can extend it up to a period of 5 years. That means from 2017 to 2022 December. So why he is now little bit aggrieved that he could not avail the full quantum of that benefit, which otherwise was not there initially when he actually changed his position, if we have to believe him, then he could have got another 2 years period for requesting the finance department to give the extension up to 2022 September. It should be 5 years maximum.
So under the policy, he is entitled for how many?
7 years under the original policy.
From 13 to 20.
13 to 20 September.
But under this scheme, you say it goes even beyond the policy.
Beyond the policy. This is an additional thing. But on the basis of this policy, he has not acted anything. Whatever he has done on the basis of the 2008 and 2009 policy and scheme. 17, the state government could not, even the state government, there was no bounding. There was no binding effect to the state government to give them. There is no enforceable right. But as a goodwill gesture, state government decided that as we have promised certain things, so let it continue. But in 2020, why state government has withdrawn it? Now, he is trying to bring discrimination on the basis of a document which is annexed as Annexure 8, 2006, page 216. According to him, some industries are getting benefit for 5 years, additional, that means beyond 7 years, and he is not getting. Now, Lordship will kindly mark the dates here. Government of Assam, Finance Taxation Department, order dated 9th November 2020. In exercise of the power conferred by the proviso to clause 1 of subpara 1 of para 4, which I have just placed, of the Assam Industries Tax Reimbursement for Eligible Units Scheme 2017, the Finance Department, Government of Assam, is hereby pleased to extend the period of eligibility dated 18/6/2019, issued to Varun Beverages Limited so-and-so by a further period of 5 years. Hence, the validity period of the said eligibility certificate, which was originally granted for a period of 7 years from 2/3/2013 to 1/3/2020, as well as the validity period of the corresponding certificate of entitlement, extended up to 1/3/2025. So, what I am trying to emphasize before this honorable court, that this order was issued on 9th November 2020 on the basis of an application submitted in the month of March 2020. Both these events, the date of submission of application and the issuance of this expansion or extension certificate was in March and November 2020. The date I am trying to find on which date it was submitted. It was sometime in the month of March.
So this extension certificate was issued on November 2020. And in December, the whole scheme was withdrawn. According to him, he had submitted an application after expiry of his period of exemption, that is in September 2020. And during the pendency for consideration of his certificate, the impugned amendment had come into place. So there is a timeline. A cutoff date.
Petitioner applied
After expiry, that is in September. We'll give the date. My learned friend will be able to give the exact date, but it is sometime after expiry. Here it is, somewhere it is written in its pleadings. Yes, he submitted on 18/8/2020.
to expiry of what?
Expiry of his period, 7 years period. Then only the additional period is required.
On which date?
18th of August
2020.
2020. Annexure 7, page 214. So within 3-4 months, the scheme was withdrawn. And that withdrawn is challenged here. It is not that the day you submit, you get the extension. Certain exercise has to be done. Genuine reasons to assess the genuine, etc. It takes time. So far as the other party is concerned, who submitted the application much before, sometime once it was expired in the month of March. So either he submitted in March or in February. So there is a long period. So during which the scheme was in force, the decision was taken. In his case and other petitioners also, and there are a lot of other units who had submitted at the fag just prior to the issuance of the notification for amendment and withdrawal of the scheme on 30th December. So those who got the benefit, we cannot say that there is discrimination. Those who had submitted their applications well in advance, because their the final date of expiry was falling much before December 2020, a reasonable time has to be taken by the department to dispose of the application. So this notification issued in favor of this unit called Varun Beverages, issued on 9th of November. The reasonable time the department took was more than about 8-9 months.
So you are submitting that those industries who have been given the benefit,
yes,
they submitted their
well in
application
advance.
for extension well in advance before expiry of their period.
Before expiry, and there was sufficient time available for the department to assess whether it is a genuine reason which should be considered for a deserving unit.
So well before the period of
Only that is not only the criteria, because Apparently, they have submitted either in February or in March.
No, no. We want to understand it. You are submitting that those industries who were considered and given the benefit,
Yes,
they submitted prior to expiry of the exemption period.
absolutely. Not only prior to it, that is one part. The other part is the order of extension was also issued prior to 30th of December 2020. And lot of other industries who have applied in 2018, 2017, 2019, they all got the benefit. Now, why this was done, Lordship? The basic reason in our affidavit I am going to place, the requirement to have sufficient revenue to the state. Why? From March onwards, the COVID was there in the state of Assam along with other parts of the world. So the whole economy crumbled. 24th March, if Lordship remembers, was the first date when actually COVID started in our country. And only because of COVID, when the economy was totally crumbling and crashing down, and the government's expenditure in the healthcare sector multiplied manifold. So ultimately, public interest must prevail over private interest. But so far as this particular unit is concerned, whatever was promised, it was fulfilled. He got full benefit up to September 2020. So whether that can be a good ground to set aside a scheme. In other words, my submission is that there is no violation of the promissory estoppel because he acted on the basis of the 2008 policy and 2009 scheme. He did not acted upon the 2017 scheme. If a new industry is established between 2017 to 2022, that argument would have been relevant. But not in the case of the present writ petitioners who got the benefit on the basis of 2008 and 2009 policy and scheme, not even under 2014. So there was another industrial policy in 2014. And subsequently to 2017, the scheme. Under that scheme also, many industries, new industries flourished. They can say that our promise has been scuttled in the midway. But so far as the present writ petitioner is concerned, in my humble submission, they avail full benefit whatever was promised because that upper limit extension, that was not a concept in the earlier industrial policies as industrial schemes. Now let us place what exactly is the fact and how we have countered in our affidavit. 2-3 paragraphs I would like to place from my affidavit. Affidavit of respondent number 5, Arunima Chaudhary signed this affidavit. I would like to read 3 paragraphs. One paragraph is quite lengthy, paragraph 5. It says the whole story. That as regard to the statements made in paragraph 3 of the writ petition, challenging the legality and validity of the notification dated 30/12/2020 issued by the government of Assam through Finance Taxation Department amending the Assam Industries Tax Reimbursement for Eligible Units Amendment Scheme 2020, the deponent submits that the contrary to the assertions sought to be made in paragraph 3 of the writ petition, the said notification is rational, valid, and legal. Moreover, the contention of the petitioner that the said notification violates Article 14 of the Constitution is baseless. The deponent submits that to give effect to the provisions of the promises made and incentives declared in the Industrial Policy of Assam 2008, the government framed the Assam Industries Tax Exemption Scheme 2009, which provides tax incentives to eligible industrial units for a period of 7 years, subject to the eligible monetary ceiling. Similarly, the Assam Industries Tax Exemption Scheme 2015 was framed by the government to provide tax incentives for investors as provisions and incentives declared by the Industrial Policy of Assam 2014 in the manner tax exemption for a period of 15 years subject to eligible monetary criteria. So he does not come under 2014 and 2015. His case is 2008 and 2009. So in 2014 industrial policy and 2015 scheme lordship, the benefit is for a period of 15 years. That also is considered by the 2017 scheme. The petitioner Lalit Poly Weave LLP established an industrial unit for manufacturing of PP-HP woven sacks, bags using PP granules, calcium, etc. as raw materials. The unit commenced its commercial production on 21st September 2013, and therefore it is covered by the industrial policy of 2008 and the relevant industrial policy in the Assam Industries Tax Exemption Scheme 2009. The unit was issued eligibility certificate by the Industry and Commerce Department under the industrial policy of Assam 2008 and the Assam Industries Exemption Scheme 2009 for a period of 7 years with effect from 21/9/2013 to 29/2020. So he availed everything here. Subject to the monetary limit of 11 crores 83 lakhs 54,569. Subsequently, entitlement certificate granting VAT exemption under the scheme was also issued. That was issued in 2016. Therefore, there was two limits under the industrial policy of Assam 2008, that is monetary ceiling and time limit. There are two areas of concept. The industrial policy of Assam 2008 and the corresponding scheme of 2009 had a clear condition that if the unit is unable to use its monetary tax incentive within the specified period of 7 years, the balance unutilized amounts would lapse. There is a specific provision under the 2008 policy. Against the available limit of tax exemption of 1183.54 lakhs, the unit availed exemption remission amounting to 456.20 lakhs during the VAT period with effect from 30/9/2017. Thereafter, during the GST regime, the unit availed tax exemption amounting to 52.88 lakhs till September 2020. Thus, the unit availed a total tax exemption amounting to 509.09 lakhs out of the total exemption of 1180.54 lakhs, which was granted to the unit. It is evident that the unit utilized 38% of the total amount of exemptions granted during the nearly 4 years under the VAT regime. During the VAT regime under the Industrial Policy 2009, the eligible unit was allowed 99% remission of the tax due, and they had to deposit 1%. Subsequently, it was 100%. The Goods and Service Tax Act 2017, which was introduced across the country with effect from 1/7/2017, brought about a structural change in the indirect tax administration of the country. The system of tax remission exemption granted during the VAT regime was not found compatible with GST regime. However, the state government was fully aware of the fact that many industrial units which were set up during the validity period of the Industrial Policy of 2008 and Industrial Policy of 2014 did not yet fully exhaust or utilize their monetary ceiling of exemption within the specified time period. Keeping this aspect in mind and to honor its past commitment, the state government, after introduction of GST, framed Assam Industries Tax Reimbursement for Eligible Units Scheme 2017, whereby the unavailed unutilized amount of monetary incentive and the unexpired period limit was carried forward in its entirety. Such units have been allowed to claim 100% reimbursement of the SGST paid by them instead of earlier 99% remission. Further, adequate budgetary provisions was also made. The utilization details of the petitioner's units are tabulated below. So that figure, Lordship, will kindly come to the next page. So he availed from 21/9/2013 to 29/2027 years. The amount is also given for both the different tax regimes. At this stage, it needs mention that here that the petitioners unit was set up in 2013 under the industrial policy of 8, and whatever incentives were available under the SAID's policy and its corresponding scheme of 2009 were granted to the unit by eligibility certificate and certificate of entitlement, and the unit enjoyed the same for 5 years during the VAT regime and even thereafter during the GST regime. So the state government has not curtailed the incentive available to the unit in any manner. Rather, even after structural change in tax regime from VAT to GST, the state government continued to provide the incentive through compatible reimbursement mechanism during GST period, although under no compulsion. In fact, Assam is the first state in the entire country to come out with such novel GST reimbursement scheme. So other states have not adopted. Most of the states, in fact, have not adopted because that handle was given by GST Council. Their Lordship, a lot of meetings had taken place during that period, prior to promulgation of the GST and thereafter also 2-3 years. So there are huge deliberations in one of the Supreme Court judgment. Everything is recorded. If required, I can produce that also. While formulating the reimbursement scheme of 2017, the government also kept the provisions for extension of period of eligibility for further period not exceeding 5 years for the units which could not achieve the full quantum of monetary ceiling due to some genuine reasons. So when we have formulated this scheme in 2017, nobody thought about that a situation with COVID will come, that where everything will come to a standstill. Had there been no COVID, the 2020's 30th December's notification would not have been issued. But that's unforeseen circumstances compelled the government, because government also did not thought that all the business activities will come to a standstill, and at the same time, manifold expenditure will be required to pump money into the health sector. All these vaccines, then ICUs, hospitals, ambulances, medicines, camps, etc. These are not part of the regular budgetary provision. So this is a situation which was never contemplated under any normal circumstance. In 100 years, this came up. Again, now it is not there. But even there was no flights. Now, to take up the brunt, Lordship will take the example of airlines sector. The way they increased the flight fares after it was resumed, normal people avoided flights. Huge raise in the price. What about the hotels? The normal hotel prices, which was 4,000, 5,000, were selling at 20,000 or 25,000. So the whole economy gone for a toss after the resumption also. So the Assam government was compelled to issue the notification on 30th December 2020. May I continue further? However, after granting extension of eligibility to a few industrial units, it was realized that the continuation of such provision was impacting the state revenue of the state. It is a matter of common knowledge that COVID-induced lockdown restriction had severe negative impact on the economy and consequently denting the revenue generation of both states and centers. The government of Assam had to resort to austerity measures to tackle the economic crisis caused by the pandemic. This is the core area of my opinion. That for this reason, we have to withdraw that scheme. Nothing else. There no explanation or no elaboration is required also. Everybody knows, Lordship, that what was the situation for 2.5 years. It needs to be borne in mind that the provision of extension of time limit in the eligibility certificate never existed in the industrial policy of 2008 and the relevant scheme of 2009. This is also very important. On the basis of which he acted, there was no such promise that beyond 5 years or beyond 7 years, if you cannot exhaust the upper limit regarding the quantum of benefit, financial benefit, it cannot be extended. So the question of breach of promissory estoppel does not and cannot arise at all. More so when the petitioner's unit was set up in 2013 under the industrial policy of 2008, which did not have such provisions for extension, and the tax incentive for the available time period under 2000 policy have not been curtailed, withdrawn, touched in any manner. The provision for extension was withdrawn under the Industrial Assam Industries Tax Reimbursement for Eligible Units Scheme 2017, and the petitioner did not have any scope occasion to alter his position. So his whole argument that he has changed his position because of the promise does not have any legs to stand. So the claim for violation of breach or breach of promissory estoppel is not sustainable in the eye of law so far as the petitioner is concerned. It is settled position of law that public interest overrides the private interest. In the instant case, it is not the case of the petitioner that the tax incentive available to him under the industrial policy of 2008 or the period of such exemption remission has been withdrawn or curtailed. The special provisions of the extension introduced in the reimbursement scheme after introduction of GST has only been withdrawn in public interest considering the impact of COVID on revenue generation of the state. As such, the government decided to withdraw the provision of the extension by notification dated 30/12/2020. It is pertinent to mention here that the withdrawal of the provisions for extension of eligibility was done by the government in public interest, which overrides any consideration of private loss or gain. The contention of the petitioner that the discrimination has been made by the government in the context of Article 14 of the Constitution of India, whereby few industrial units were granted extension of eligibility prior to the amendment, and the industrial units whose applications were pending on the effective date were deemed to be rejected, is strongly denied and contended. It is a fact that extension of eligibility has been granted to few industrial units by the government during the time when the clause was in force. So the notification which they have annexed as Annexure 8 was issued in the month of November. The withdrawal was done in December 38th. So there is no discrimination. It is well settled that the guarantee of equal protection of laws does not require that the same law should be applicable to all persons. Article 14 does not forbid classification for legislative purposes, provided such classification is based on some differentia having a reasonable relation to the objects and purpose of the law in question. There is a strong presumption in favor of the validity of legislative classification, and it is for those who challenge it as unconstitutional to prove beyond all doubt that the legislation arbitrarily discriminates between different persons similarly circumstanced. It is now well settled that though taxing laws are not outside Article 14, however, having regard to the wide variety of diverse economic criteria that go into the formulation of a fiscal policy, the legislature enjoys a wide latitude in the matter of selection of persons, subject matter, events, etc. for taxation. The taste of the vice of discrimination in a taxing law are accordingly less rigorous. A legislature does not, as an old saying goes, have to tax everything in order to be able to tax something. If there is a equality and uniformity within such each group, the law would not be discriminatory. The only classification which amounts to discrimination is the one between the objects for which and the legislature in question there is no rational relationship or nexus. Subject to the aforesaid condition, valid classification of person or objects can be made by a lawmaking authority on any approved basis, that is occupation, standing, age, locality, point of time. Here it is the point of time. Then coming to paragraph 8, page 230. The deponent begs to state that the eligibility certificate is issued to an eligible units providing tax exemption for a particular period subject to the monetary ceiling, and either of those two components, period and the monetary ceiling, whichever exhausts earlier, ceases the eligibility status of the industry. As such, the petitioner has admitted in his paragraph that he has enjoyed the exemption for a period of 7 years with effect from 21/9/2013 to 29/2013, and have been able to utilize the monetary ceiling of 5 crores 9 lakhs 9,549 against the available limit of 11 crores, etc., from the date of commencement of the business till 29 2020. This implies that the industry has fully availed the benefit and exhausted his tenure of the 7 years period. As such, there is no merit in his contention regarding injustice to him for the removal of clause 411 of the Assam Industries Tax Reimbursement for Eligible Units Scheme 2017 by notification dated 30/12/2020. The details are given up. Paragraph 9, we have basically said the petitioner enjoyed the benefits provided under the said scheme from time to time till the end of the validity period as originally provided in the eligibility certificate. So whatever certificate he is in possession, Lordship, he has availed everything. Only thing is that extension could not be granted to him. So now, these are the basic contention of the State Department. Now what we will have to see. First is that whether there is a violation of the promissory estoppel. If we have made any promise, whether there is any violation or we fail to keep our promise. Our promise on the basis of which he acted does not have any clause for extension of the period of 7 years. Original. Because he has not acted anything on the basis of 2017 scheme. What he has done on the basis of 2017 scheme is only submitting an application of 18th of August 2020 after the when his period was coming to an end. There is no case of pumping any additional fund or expansion of his activities. I have gone through his petition, Lordship. There is no such situation also. In fact, those situations are not relevant. In some situations, if there is expansion, then
this is industrial policy 2008.
And industrial scheme 2009. So there is no question of violation of any promissory estoppel so far as writ petitioner is concerned. Now, whether, suppose, let us think that he establishes a unit after 2017. And after 3 years of benefit, when the existing units or the newly established units after 2017, if the government decides to close the scheme or the beneficiary policy, whether that is permissible or not.
No, you have to come again. See, under the Industrial Policy Act, there is a particular time
Frame.
frame.
Yes.
Certain exemptions are granted. Then, insofar as the benefits for taxation are concerned, this scheme has been included.
Yes.
Now, under this scheme, there was a provision for continuing the benefits for if he was not able to exhaust.
Absolutely, Lordship. But
limit.
Yes, Lordship is right so far as if it is a case of 2008. His whole initiation, why these industrial policies are floated? We have to look into the objective. The government floats the industrial policies or frames the industrial policies to attract investors to set up industry. So when it was done in 2008, government said, you come, invest, set up units from the date of commercial production. There will be no taxation, 99% remission, 1% tax you have to deposit for a period of 7 years from the date of commercial production. Along with that, you will also get another benefit of 5 years exemption in the power subsidy. These are the two areas where the government induces the investor to invest for having more industries in our state. Identically in other states also, they have their respective industrial policies. In 2008, the scope of the policy as well as the scheme is very well defined. That within 7 years' time, you will get this remission. You can avail a maximum. There are two parts. One is the time limit, 7 years, and on the basis of his investment, he is entitled for 11 crores and some odd amount. But you have to avail that benefit within that 7 years period. Beyond 7 years, there is no scope. On the 8th year, you have to pay 100% of your taxes. During this period of 7 years, the tax regime changed. From VAT, it has come to GST from 1/7/2017. When a new regime comes, under the new regime, there is no scope for any exemption or industrial policy. Because 2008 also, if you go, then it has a connect with the VAT Act of 2005. So under the GST Act, there was none. And the statutory body, which is taking whole responsibility of implementing GST throughout the country, they said that if any industries are getting any benefit of exemption, there is no mandatory requirement of continue that provisions. However, state government or central government can take a decision on their own. If they want to continue with the benefit, suppose for the state, it is the state government's tax part. There are two components in GST. One is a IGST, one is the state GST. So far as the state part is concerned, the Assam government decided that whatever benefit we floated at the point of issuing the eligibility certificate or at the introduction of the industrial policy in 2008 for 7 years and 2014 for 15 years. If those periods are still in force, then we'll continue with that. But instead of 99% taxation exemption, 1% tax to be paid, this time government decided that it will be for 100% exemption for the state component, because the central component they have to pay. And in the new scheme, it was also introduced that upper limit regarding the exemption quantum, that 11 crores, if they fail to avail that within the time frame, that is 7 years, and if they can show that there are genuine grounds for which they cannot avail 100%. In that situation, the finance department will take a call. They will do the assessment. They will verify whether he has rightly or genuinely deserved that benefit or not. An exercise has to be done. He has to establish his case that he has, for genuine reasons, he could not do. Now, the genuine reasons, if we look, have a cursory look. For 7 years period, he could avail only 38%. Nobody stopped him. There was no COVID. So whatever he projected before the industries department or to the finance department, that he will do this kind of production and he will get 11. How this 11 crores amount figure cropped up? Because he projected that my production will be X, but he failed to produce X less than X. Therefore, he could avail only 38%, not 100%. Suppose this scheme is there. Suppose he is entitled for another period of 2 years. Suppose, let us assume, he has submitted his application on 18th of August. And if the finance department finds that for long 7 years, you could not avail even 50%, even 40% of what you are entitled to, What is the reason? What will convince the finance department to give him extension? Because he has miserably failed in his production output. So in that view of the matter, even if that 30th December notification was not issued, what is the guarantee that he can avail for the remaining period, even if it is extended till September 2022? Because maximum he will get up to September 2022. Under the 2017 scheme, it is for another 5 years. So his main grievance is that another 2 years he wants. But for the first 7 years, he could not avail even 40%. He could avail only 38%. So another 62% he wants to get the benefit in next 2 years. Anyway, that is beyond the pleadings. But in my arguments, I'm just submitting before this honorable court, because he is challenging the decision of the government to withdraw it. First, we have to see what is his status. When he says that promissory estoppel has been violated, first he has to establish before this court that we have failed to act upon our promise. We have resigned from our promise, which we have not done. 2017 scheme is just a beneficial scheme. Others are also beneficial, but in the other part, the distinction is that on the basis of 2008 and 2009, he acted, he invested money. Lordship will not find a single whisper that after 2017, he has done anything on the basis of 2017 scheme regarding his investment. Why these promises are made? To induce the people to invest more, so that the overall economy grows, more employment, more activities in the economy takes place in the state. That is why this industrial policy. Otherwise, what is the reason of giving exemption of 100% or 99% tax exemption for a long period of 7 years? So the basic objective is very clear. Now, why we have to resign from this scheme of 2017 in respect of those who are not completing their tenure or they want extension? Because the situation demanded it. One individual may have some, maybe he will get another advantage of another 10%. Maybe it will go up to 48% for next 2 years. But we have to see the bigger picture. The state government also have to run, and more so in case of emergency.
Now, in respect of his claim that there was discriminatory,
He has annexed this document, page 216. So that industry got the benefit within the period when the scheme was in force.
Have you addressed anything in the affidavit to that effect?
Yes, one line is there. One line is there. Very clearly we have stated. Page 227. Let us start from page 226, last 2 lines. Have Lordship got it?
Yes.
The contention of the petitioner that the discrimination has been made by the government in the context of Article 14 of the Constitution of India, whereby few industrial units were granted extension of the eligibility prior to the amendment, and the industrial units whose applications were pending on the effective date of amendment were deemed to be rejected, is strongly denied and contended. It is a fact that the extension of eligibility has been granted to a few industries by the government during the time when the clause was in force. That clause 4 was in force. That is why this date I am repeating, Lordship. I said that this date is very important of page 216, 9th of November, 2020, which is 1 month, 20 days earlier to the withdrawal. It's a cutoff date, Lordship. Basically, those who received the benefit before the withdrawal or before the amendment, they will get the entitlement. And their case was at the fag end. Somewhere we have to draw the line. Suppose it was done in April 2021. Suppose his application would have been disposed of by that time. Some new industries will have the same grievance. When there is a cut-off date, there are always some people who are aggrieved and some people who got the benefit. There are people on either side of the fence when there is a cut-off date, whether it is for age, for qualification, in every field. The law is well settled regarding cut-off date. So the cut-off date here is 30th of December 2020. And Lordship remembers how the things progressed in the year from March till December. Absolutely everything was standstill, and there was no business activities, no revenue generation from the government. So we have to generate some revenue. So these benefits we have to withdraw, because in ideal situation, this would not have been done. So I have to place some judgments. If Lordship wants to hear it start right now or maybe at 2 o'clock. It is 1 o'clock now.
Resume at 2.
Yes.
These arguments that you are making will take care of the other writ petitions also, except for minor
here and minor factual differences. মই এটা পাইছো নৱেম্বৰত উলিয়ালা এইখন মাৰ্চত ক'ত পাইছো ভালকে পঢ়াটো এইটো ক'ত মই পাইছো এইটো হয় মাৰ্চৰ ক'ত পাইছো কোন ডিপাৰ্টমেণ্ট অফ মোহন নহয় না Maitri Lordship. So the first judgment which I would like to rely is Kasinka Trading and Another versus Union of India, 1995, Volume 1 SCC, page 274. These are to counter their arguments on promissory estoppel. Paragraph 11, Lord.
Before 11, I am just reading few lines from paragraph 5. The respondents have supported the judgment of the High Court and urged that though the doctrine of promissory estoppel can in appropriate cases be invoked against the government to bind it to its promise, the doctrine, however, has no application to the present appeal because the exemption has been withdrawn in public interest and the individual interest must give way to the public interest. It is urged that the doctrine, being a product of equity, must give way when equity so demands. So now coming to paragraph 11. The doctrine of promissory estoppel or equitable estoppel is well established in the administrative law in the country. To put it simply, the doctrine represents a principle evolved by equity to avoid injustice. The basis of the doctrine is that where any party has, by his word or conduct, made to the other party an unequivocal promise or representation by word or conduct, which is intended to create legal relations or affect a legal relationship to arise in the future, knowing as well as intending that the representation, assurance, or promise would be acted upon by the other party to whom it has been made and has in fact been so acted upon by the other party, the promise, assurance, or representation should be binding on the party making it, and that party should not be permitted to go back upon it if it would be inequitable to allow him to do so. However, regard to the dealings which have taken place or are intended to take place between the parties. It has been settled by this court that the doctrine of promissory estoppel is applicable against the government, also particularly where it is necessary to prevent fraud or manifest injustice. The doctrine, however, cannot be pressed into aid to compel the government or the public authority to carry out a representation or promise which is contrary to law or which is outside the authority or power of the officer of the government or of the public authority. There is preponderance of judicial opinion that to invoke the doctrine of promissory estoppel, clear, sound, and positive foundation must be laid in the petition itself by the party invoking the doctrine, and that bold expression without any supporting material to the effect that the doctrine is affected because the party invoking the doctrine has altered his position, relying on the assurance of the government, would not be sufficient to press into aid of the doctrine. In our opinion, the doctrine of promissory estoppel cannot be invoked in the abstract, and the courts are bound to consider all aspects, including the results sought to be achieved and the public good at large, because while considering the applicability of the doctrine, the court have to do equity, and the fundamental principles of equity must be ever be present in the mind of the court while considering the applicability of the doctrine. The doctrine must yield when the equity so demands, if it can be shown, having regard to the facts and circumstances of the case, that it would be inequitable to hold the government or the public authority to its promise, assurance, or representation. The ambit, scope, and amplitude of the doctrine of promissory estoppel has been evolved in this country over the quarter of a century through successive decisions, starting from Union of India versus a series of cases are quoted here. I am leaving these judgments which are quoted here. Coming to paragraph 20. The fact of the appeal before us has not analogous to the fact of the Info-Afghan agencies. In the first case, the petitioner herein had acted upon the unequivocal promise held out to it and exported good to the on a specific assurance given to it. It was in that fact situation that it was held that textile commissioner who had enunciated the scheme was bound by the assurance thereof and obliged to carry out the promise made thereunder. Already noticed above, in the present batches of cases, neither the notification is an executive character nor it represents a scheme designed to achieve the particular purpose. It was a notification issued in public interest and again withdrawn in public interest. So far as the second case, MP Sugar, is concerned, the facts are totally different. In correspondence exchange between the state and the petitioner therein, it was held that the petitioner that the industry would be exempted from sale tax for a particular number of initial years. But when the state sought to levy the sale tax, it was held by this court that it was precluded from doing so because the categorical representation made by it to the petitioners to letters in writing who had relied upon the same and set the industry. The power to grant exemption from payment of duty, additional duty under the Act was already noticed, flows from the provisions of Section 25 of the Act. The power to exempt includes power to modify and withdraw the same. In our case, all these exemption notifications were issued. There is a provision under the Act, Section 25. Under which? Section 54, I think, if I'm not wrong.
54.
54. Huh?
Exemptions
In VAT. Under VAT, Section 54. Section 54 of the Assam Value-Added Tax. Subject to such condition as it may impose, the government may, if it is necessary to do so, in the public interest. Yes. Exemption of certain sales and purchase. Subject to such condition as it may impose, the government may, if it is necessary to do so in the public interest, by notification in the official gazette, exempt by way of an appropriate scheme or otherwise in conformity with the provision of this Act, any sales or purchase made by to or by a class of dealers or persons specified in the said notification from payment of the whole or any part of tax payable under the provision of this Act, and notification issued under this section may be issued so as to be retrospective to any date not earlier than the date of commencement of the Act, and such exemption shall take effect on the date of publication of the notification in the official gazette, and such other earlier or later date as may be mentioned herein, provided that the government may withdraw such exemption at any time as it may think fit and proper, provided that when the exemption is granted in the form of remission, the dealer shall be entitled to retain the part of the or whole of the tax collected by it of subsidy from the government subject to maximum permissible monetary limit and or time limit and other conditions as may be prescribed in the appropriate scheme. So this is precisely what is there in the scheme as well as the policy of 2008. Paragraph 23 says, the appellant appears to be under the impression that even if in the altered market conditions, the continuation of the exemption may not have been justified, yet government was bound to continue to give its extra profit to them. That certainly was not the object of which the notification has been issued. The withdrawal of exemption in public interest is a matter of policy. It is what I am emphasizing. The withdrawal of exemption in public interest is a matter of policy, and the court would not bind the government to its policy decision for all times to come, irrespective of the satisfaction of the government that a change in the policy was necessary in public interest. The court do not interfere with the fiscal policy where the government acts in public interest, and neither any fraud or lack of bona fide is alleged, much less established. The government has to be left free to determine the priorities in matter of utilization of finances and to act in the public interest where issuing or modifying or withdrawing any exemption notification under Section 225 of the Act. So a lot of leeway is given. Paragraph 25, in our considered opinion, therefore, the High Court was perfectly right in holding that the doctrine of promissory estoppel had no application to the impugn notification issued by the central government in exercise of its power under Section 25 of the Act in view of the facts and circumstances as established on the record. So here also Section 25, the power to give and power to withdraw was there. Identical power is there in our case also. And when it is done in public interest, Lordship, normally the court would not like to interfere. That is the law laid down in Kasinka trading, followed by subsequent lot of judgments. And one more thing, I am repeating once more. They have not changed their position in terms of the promise of 2017. Whatever was committed, whatever was promised, whatever was represented in 2008 and 2009 on the basis of those policy and the scheme, they avail everything whatever was due to them. But under no circumstances, they have changed their position post 2017. And Section 54 very clearly says the government has the right to give and right to withdraw with genuine grounds. Now, the genuine grounds here is that the COVID, the lack of revenue generation. It was done in December after the first phase of COVID was over. Then from January, the second round of COVID started. Now, next judgment is 1997, 3 SCC. These are landmark judgment, both Kasinka and Sriji sales. 1997, 3 SCC pays 394. Sriji Sales Corporation and another versus State of Assam, Union of India. Paragraph 3, 4, and 7. Here may I read the first paragraph for the facts. The present appeal impugns the judgment of the High Court of Delhi dated 16/3/1983, which dismissed the writ petitions filed by the appellant challenging the notification dated 16/10/1980 issued by the Government Ministry of Finance, Department of Revenue being notification so and so. This notification was issued in supersession of an earlier notification of 15/3/1979 dated so and so. By the first notification, the government gave exemption to imports of polyvinyl chloride resin PVC falling under Chapter 39 of the first schedule from the duty of customs leviable there under specified in the first schedule, the relevant part of the notification. The first notification was granting exemption. The notification shall be in force up to and inclusive of 31st March 1981. The case of the appellant is that on the faith of the solemn assurance given by the Government of India that no duty of customs would be leviable on the importation of PVC resins up to 31/3/1981, they entered into an arrangement with the import of PVC resins as an actual user in the UP Export Corporation Kanpur and opened letter of credit against the foreign suppliers on 2/10/1980, and the goods arrived at the Bombay port on 8/11/1990. However, the notification withdrawing the exemption from payment of custom duty was issued on 16/10/1980. Relevant part of the notification is hereunder. So it should be valid up to 31st March 1981, but at least 5 months prior to the date of expiry of the first notification, the subsequent notification was issued to withdraw the exemption. In that situation, the challenge was before the court. Coming to paragraph 3. It is not necessary for us to go into the historical analysis of the case law relating to promissory estoppel against the government. Suffice it to say that the principle of promissory estoppel is applicable against the government, but in case there is a supervening public equity, the government would be allowed to change its stand. It would then be able to withdraw from the representation made by it, which induce persons to take certain steps which may gone adverse to the interests of such persons on account of such withdrawal. However, the court must satisfy itself that such a public interest exists. Definitely, Lordship would have to examine whether COVID is a valid ground or not, cogent ground or not for withdrawal. In our affidavit, we in categorical terms, we have stated that because of the COVID only, we have withdrawn and amended clause 4 of the scheme. The law in this aspect has been emphatically laid down in the Motilal Padampat Sugar versus so-and-so, the relevant portion for our purposes extracted below. It is only if the court is satisfied on proper and adequate material placed by the government that overriding public interest requires the government should not be held bound by the promise but should be free to act unfettered by it, that the court would refuse to enforce the promise against the government. The court would not act on a mere ipsi dixi of the government, for it is the court which has to decide and not the government whether the government should be held exempt from liability. This is the essence of the rule of law. The burden would be upon the government to show that public interest is in the government acting otherwise than in accordance with the promise is so overwhelming that it would be inequitable to hold the government bound by the promise, and the court would insist on a highly rigorous standard of proof in the discharge of its burden. But even where there is no such overriding public interest, it may still be competent to the government to resile from the promise on giving reasonable notice, which needs not be a formal notice, giving the promisee a reasonable opportunity of resuming his position, provided, of course, it is possible for the promisee to restore status and qua ante. If, however, the promisee cannot resume his position, the promise would become final and irrevocable. Two propositions follow from the above analysis. Number one, the determination of applicability of promissory estoppel against public authorities, government hinges upon balance of equity or public interest. So what I am thirsting upon the present case is public interest here. And number two, it is the court which has to determine whether the government should be held exempt from the liability of the promise or representation. In the present case, the first notification exempting the custom duty on PVC itself recites, central government being satisfied that it is necessary in public interest to do so. In the notification issued later, which give rise to the present cause of action, the same recitation is present. Next case, they are relying upon the Kasinga. The Kasinga paragraph 19, the part I have just placed that judgment. Paragraph 19 is quoted here. Yes. Coming to paragraph 6 and 7. It has been seen that the High Court in the case of Bombay Conductors had noticed a similar public interest in withdrawing the notification of exemption. The appellant in the present case have not disclosed any fact which would show the existence of better equity in their favor. All that they have alleged that they would not have been imported PVC resin without the exemption, as that would become unviable or uneconomical, and further, many persons took advantage of the exemption. However, the exemptions accorded preferential treatment to some person, but not to the appellant. The fact of the economic situation explained in the judgment of Kasinga may not have been controverted, nor it is alleged by the appellant that the public interest did not call for supersession of the notification 66. The next question is whether the fact that the notification 66 mentioned the period during which it has to remain in force would make any difference to the situation. In other words, could it be said that an exemption notification without specifying the period within which the exemption would remain in force would be withdrawn in public interest, but not the one in which a period has been so specified? Once public interest is accepted by the superior as a superior equity, which can override individual equity, the principle should be applicable even in cases where a period has been indicated. The government is competent to resile from a promise even if there is no manifest public interest involved, provided, of course, no one is put in any adverse situation which cannot be rectified. To adopt the line of reasoning in Emmanuel so-and-so and quoted in MP Sugar, where even there is no such overriding public interest, it may still within the competence of the government to resile from the promise on giving reasonable notice, which need not be a formal one, giving the promisee a reasonable opportunity of resuming his position, provided, of course, it is possible for the promisee to restore the status quo ante.
If, however, the promisee cannot resume his provision, the promise would become final and irrevocable. However, in the present case, there is a supervening public interest, hence it would not be mandatory for the government to give a notice before withdrawing the exemption. In our opinion, the judgment in Kasinka is based on a correct analysis of facts and law. We see no reasons to differ from the judgment. The present appeal is accordingly dismissed. May I just take your lordship to paragraph 5, where Kasinka is quoted, paragraph 19, which I have not placed. In Kasinka, this court had actually gone into this aspect. In paragraph 19, the court says PVC resin is not disputed, is manufactured in India and is also imported from abroad. In the counter to the writ petition filed by the Union of India in the High Court, the justification for the issuance of the exemption notification 66 of 1979 in the public interest was spelled out by the respondents. It was stated that it was with a view of equalizing sale prices of the indigenous and the imported materials and to make commodity available to the consumer at a uniform price, keeping in view the trend in the public in the supply of material, that the cabinet had decided to issue the exemption notification 66 of 99 under section 25 of the Act. Subsequently, when it was found that and realized that the international prices of the products are falling and consequently the import prices have become lower than the ex-factory prices of the indigenous materials, the materials was examined by the government of India and it was decided in public interest to withdraw the exemption notification. Thus, the Union of India has disclosed the circumstances under which the exemption was initially granted as well as the change in circumstances which warranted the withdrawal of the exemption notification. The reason given by the Union of India justifying withdrawal of the exemption notification, in our opinion, are not irrelevant to the exercise of the power in public interest, nor are the same shown to be insufficient to support the exercise of that power. From the materials on record, it is apparent that the exemption notification issued under Section 25 of the Act in public interest was designed to offset the excess price which the local entrepreneurs were required to pay for importing PVC resins at a time when the difference between the indigenous products and the imported products was substantial. No importers could be expected to import PVC resins after paying duty and incur losses. The exemption notification was therefore issued with a view to offset those losses to the extent possible. The exemption notification was not issued as a potential source of extra profit for the importer. Again, at the time when the notification was withdrawn by the government, there was no scope for any loss to the suffered by the importer, as was clearly stated in the counter affidavit filed by Union of India, and which contention has remained unrebutted. From the counter filed by the Union India in the High Court, it is abundantly clear that the necessity of the continuation of the exemption in view of the changed circumstances was no longer necessary. So in our case, Lordship, they have not been able to place anything on facts in their pleading that after 2017 scheme, where there was an insertion of a provision for extension of the period of exemption beyond 7 years was inserted. On the basis of that promise, whether they have acted anything or whether they have invested anything, they have not changed their position on the basis of that particular clause, clause 4, which is amended by the amended notification of 2020 December 30th. So they have not pleaded anything that on the basis of 2017 scheme, they have changed their position or they have done something extra to get the benefit. So they have not, in these cases, on the basis of the notification, certain agreements were executed, they have planned their business, etc. In our case, they have planned their business in 2013 itself, or maybe prior to that, when the 2008 policy and 2009 scheme was floated. So their investment, their intention to establish the unit, everything was conceptualized after the 2008 policy came into force, followed by the 2009 scheme. So they have not changed, done anything extra to take benefit of the promise. Whatever was promised under those act and policy, they have already availed it.
So nothing has been deprived from them. 2017 was additional because of the change in circumstances, the change in the tax regime from VAT to GST. There is a drastic change, and under the GST, there is no scope for this kind of exemption. So the government, in its wisdom, allowed them to have this benefit till it is over, or if they can show some genuine grounds, it can be extended for another 2 years, in their case, up to 2022. Only the amendment has been done to give that extension. Nobody is deprived their due or whatever benefit accrued to them under their utilization certificate or entitlement certificate. That has not been withdrawn. What is withdrawn? In fact, the scope for extension is withdrawn. So the amendment is relating only to clause 4 of the 2017 scheme, where there is a scope for expansion or extension of the period of exemption, provided they can furnish some genuine grounds of not availing the complete benefit. What is that complete benefit? The upper limit of the quantum of tax component which they are entitled, which till 7 years expiry, they availed only 38%, not beyond that. The next case. The law is more or less laid down by the earlier judgment and followed in various cases. 2000 volume 4 SCC, 2000 volume 4 SCC, page 57, Daiichi Karkaria Limited versus Union of India, paragraph 4, paragraph 6.
1000 volume 4.
Volume 4. Next. Paragraph 6 maybe. The law on the matter is now well settled that even in respect of exemptions that may have been made by the government, the doctrine of promissory estoppel will not be applicable if the change in the stand of the government is made on account of public policy. This position has been explained in details by this court in Kasinka Trading, reiterated in Sriji Sales. In both these cases, this court is concerned with the notification issued under Section 25 of the Customs Act. In Kasinka, it is stated that the exemptions granted under Section 25 of the Customs Act in public interest is designed to offset the excess prices which the local entrepreneurs were required to pay for importing PVC resins at a time when the difference between the indigenous products and the imported products was substantial. And at a time when the notification was withdrawn by the government, there was no scope for any loss to be suffered by the importers, and therefore change of the policy was permissible. The decision is the same in Sriji Sales Corporation, wherein it was noticed that once public interest is accepted by as a superior equity, which can override individual equity, the principle would be applicable even if in cases where a period has been indicated for which the period of notification would remain in force and the government is competent to resile from a promise. It was further noticed that the government can resile from a promise even if there is no manifest public interest involved, provided, of course, that no one is put in any adverse situation which cannot be rectified. So basically the law is reiterated here. Yeah. So they have also urged that there is violation of Article 14. So from that perspective, I would like to rely 2-3 judgments. 2008 volume 5 SCC, 2008 volume 5 SCC, page 580,
paragraph 13 and 18. The appellant had questioned the validity of the act only on the ground of infringement of Article 14 of the Constitution. Apart from the fact that act is protected under Article 31B of the Constitution, having been placed in a 9th schedule thereof, even otherwise, we do not find any reasons to arrive at the conclusion that the act is ultra vires of Article 14 of the Constitution. A discrimination on the ground of valid classification which answers the test of intelligible differentia does not attract the wrath of Article 14 of the Constitution. Hardship by itself may not be the ground for holding the said provision to be unconstitutional. 14. In Ajoy Kumar Banerjee, differentiation is not always discriminatory if there is a rational nexus on the basis of which the differentiation has been made with the object sought to be achieved by a particular provision. Then such differentiation is not discriminatory and does not violate the principle of Article 14 of the Constitution. This principle is well settled now, to be reiterated that the reference to cases there is intelligible basis or for differentiation. Whether the same results or better results could be achieved, the better basis of differentiation evolved is within the domain of legislature and must be left to the wisdom of the legislature. Had it been held that the scheme of 1980 was within the authority given by the Act, we would have rejected the challenge to the Act and the scheme under Article 14 of the Constitution. No case has been made out that the Act is confiscatory in nature. No foundation fact has been brought to record. The appellant has not annexed any copy of the report. I'm not on this.
What is the name of the party?
The party's name is Seema Silk and Saris versus Director of Enforcement. What I am trying to emphasize here, Lordship, reasonable classification is permissible. Those whose expiry date of their entitlement and eligibility certificate was over before the period of COVID or during the COVID first stage, they have given their applications. Post 2017, it is not that everybody's certificate was valid till September 2020. Someone's certificate, those who have started their commercial production in 2011, 12, or 13, their 7 years period expired much before. So those who certificate expired, let us assume that in 2018, they submitted their representation that due to genuine grounds, they could not avail the maximum permissible benefit under the taxable quantum. Their cases were considered and those were found to be genuine, they got the benefit of the extension under clause 4 of the scheme. The document which they have annexed at Annexure 8, their period was also over sometime in March, that is prior to setting of COVID. And they submitted their application sometime in February, before the expiry. And their case was processed and they got the benefit of the decision of the taxation department sometime in November 2020. During this period, a process has been initiated by the government, more so once the first phase of COVID was gradually dying down, maybe in October, November. Lordship remembers. And by that time, government realized that substantial fund has been utilized for medical purpose, healthcare sector. And there is absolutely no revenue generation from the other sectors. Trade and commerce, etc. Everything was closed down. There are time limits, there are total lockdowns, etc. During that time, the file was processed that we have to generate some revenue from some sources. And one of the source was that these exemptions which was given to those persons who have already completed their 7 years initial commitment given by the government. So only that part has been amended, not the whole scheme. In fact, early this morning, I was a little bit wrong, but I gone quick. So only clause 4 has been amended. Those who have submitted applications and yet to be disposed of, 30th December was the date when the amendment was done in respect of clause 4. And clause 4 inserted that condition that those whose period of 7 years is over and beyond that, if they do not avail 100%, if there is some amount left for getting the reap the benefit, they can represent it before the finance taxation department. And if it is found to be genuine, good grounds are cited, then they can avail it beyond their 7 years period up to 2022. That means somebody will get 3 years, somebody will get 4 years, somebody will get 2 years, somebody will get, suppose it was in 2021, 1 years. They are entitled to apply for it once it is over. Suppose they took 100% benefit within September 2020. In that situation, this clause is not beneficial to him, whether it is there or it is not there. Only because he availed only 38%, therefore, he thinks he is aggrieved. In fact, he is aggrieved. That's why he has filed this petition, which is within his legal right. Now, those who have availed it, because they are trying to bring the mandate of Article 14 that some are getting benefit, some are not getting benefit. Those who have got benefit, at that point of time, there was no requirement of the government to generate some additional revenue to tide over the emergent situation. In 2019, COVID was not there. 2018, COVID was not there. 2020, till March, COVID was not there. Post 2020 March, the situation changed. Had it been for 1 month, suppose the first lockdown, after that the normalcy returns to the economy, maybe that amendment would not have taken place at all. But initially everybody was having positive thoughts that the lockdown is for 15 days, then it was extended, then there were time limits, their business establishment will be closed, there will be one shop in and one area, there will be supply to the home by the government, deputy commissioner, then large scale COVID patients, large scale of ICUs, makeshift hospitals, foods, camps, etc., etc. That created the shortage of funds. Because on one hand, your whole revenue generation is coming down. It has reached its nadir. On the other hand, in one particular sector, the revenue requirement is much higher than planned in the budget. So one of the options, it is not the sole option. There are a lot of scopes, a lot of avenues. Maybe increasing the price of the liquor. That was another source of revenue generation at that point of time. So public interest, what I am emphasizing in our affidavit also, we have repeatedly stated that because of public interest, it was done. And so far as the writ petitioner, no promise. They just got the benefit coincidentally. Because they have not acted anything on the basis of 2017 clause 4. They have acted on 2008 and 2009 only. 2017, they are getting the benefit, and they would have got the benefit had it been 2019, 2018, or maybe March 2020, which the other person got, that Vishal Industries. But so far as he is concerned, Lordship, his 7 years period was over on 21st of September 2020. So again, after the onset of the COVID. So to get the benefit of promissory estoppel also, he has to first establish his case. That on the basis of the promise, what he has done.
The promise, if we look into it, if at all there is a promise, then 7 years tax exemption plus 5 years power exemption. That he has fully availed. He could not meet the upper cap because of his own inefficiency, not because of the fault of the government. Government kept the upper ceiling, the cap at 11 crores. He availed something around 5 to 6 crores, so 38%. So it is not because of the government's fault. He could not avail 100%. It was because of his own inefficiency. He could not avail 100% during the stipulated period of 7 years. Into 2020, volume 20 SCC, page 57. On the public policy, I would like. 2020, volume 20. Page 57, Union of India versus VVL Limited. The case is basically the doctrine of promissory estoppel and withdrawal of exemption in public interest. Here the relevant paragraph will be later. Yeah. Twenty-one, na? All the cases are summed up here. Paragraph 21. While considering the aforesaid questions and before considering the nature of subsequent notification of 2008, few decisions of this court on the retrospectivity, clarificatory applicability of promissory estoppel in the fiscal statute are required to be referred to are as under. Number one is the Kasinka again. I'm not reading it again. Then 21.2 Sriji. Then 21.3. In Sri Durga Oil Mills, it has been held that when the withdrawal of exemption is in public interest, the public interest must override any consideration of private loss or gain. In the said case, the change in policy and the withdrawal of the exemption on the ground of severe resource crunch have been found to be a valid ground and to be in public interest. Squarely covers my situation, Lordship. Sri Durga Oil, that is reported in 1998, 1 SCC page 572. Yes. In Mahavir Oil Industries, after considering the decision of this court in Kasinka trading, a similar view has been taken and it has been observed that public interest requires that the state to be held bound by the promise held out by it in such a situation. But it does not preclude the state from withdrawing the benefit prospectively even during the period of the scheme if public interest so requires, even if in a case where a party has acted on the promise and if there is any supervening public interest which requires that the benefit be withdrawn or the scheme be modified, the supervening public interest would prevail over any promissory estoppel. So pausing here for a moment, he has not done anything on the 2017 clause 4 scheme. So in that situation, he cannot actually urge upon the violation of doctrine of promissory estoppel. In Sri Siddhiwali Steel versus so-and-so, paragraph 32 and 33, the court held, the doctrine of promissory estoppel is by now well recognized and well defined by a category of decisions of this court, where the government makes a promise knowing or intending that it would be acted on by the promisee, and in fact the promisee acting in reliance on it altered his position, the government would be held bound by the promise and the promise would be enforceable against the government at the instance of the promisee, notwithstanding that there is no consideration for the promise and the promise is not recorded in the form of formal contract as required under Article 229 of the Constitution. The rule of promissory estoppel being an equitable doctrine has to be molded to suit the particular situation. It is not a hard and fast rule that an elastic one. the objective of which is to do justice between the parties and to extend an equitable treatment to them. The doctrine is a principle evolved by equity to avoid injustice and to commonly named promissory estoppel. It is neither in the realm of contract nor in the realm of estoppel. For the application of the doctrine of promissory estoppel, the promisee must establish that he had suffered in detriment or altered his position by reliance on the promise. In my humble submission, he has not whispered, not uttered anything that he has changed his position, he has altered his position post 2017 clause 4 scheme. Normally, the doctrine of promissory estoppel is being applied against the government, and defense based on executive necessity would not be accepted by the court. However, if it can be shown by the government that having regard to the facts that they have subsequently transpired, it would be inequitable to hold the government to the promise made by it. The court would not raise an equity in favor of the promisee and enforce the promise against the government. Where public interest warrants, the principle of promissory estoppel cannot be invoked. It's a very important line. Where public interest warrants, the principle of promissory estoppel cannot be invoked. The government can change the policy in public interest. However, it is well settled that taking cue from this doctrine, the authority cannot be compelled to do something which is not allowed by law or prohibited by law. In fact, by an arbitrary action also, in my humble submission. But here, there is no scope of any arbitrariness. There is no promissory estoppel against a settled proposition of law. Doctrine of promissory estoppel cannot be invoked for enforcement of a promise made contrary to the law, because none of the can be compelled to act against the statute. Thus, the government or the public authority cannot be compelled to make a provision which is contrary to law. We are not on this. Thus, as the call as held by this court, when the public interest warrants, the principles of promissory estoppel cannot be invoked. It is further held that the rule of promissory estoppel, being an equitable doctrine, has to be molded to suit the particular situation. It is not a hard and fast rule but an elastic one, the objective of which is to do justice between the parties and to extend equitable treatment to them. Paragraph 23 is regarding to the factual situation, the general principles up to paragraph 21. Yes. I would like to place another judgment. 2023, volume 1, SCC, page 386. My Lord Justice Gabhai and Nagaratna. So, Hero Motocrop Limited versus Union of India. Paragraph 41, the issue is framed here. The question, therefore, that would fall for consideration is as to whether, despite a subsequent statute specifically providing for rescinding the benefits granted under an earlier statute, the Union government can be compelled to stand by the representation made by it through the earlier notification. In other words, the question that will have to be considered is whether doctrine of promissory estoppel could operate against the statute. Various judgments are cited, Lordship, from paragraph 43 onwards. I'm coming to paragraph 68. However, a common thread in all these judgments that could be noticed is that all these judgments consistently hold that there can be no estoppel against the legislature in the exercise of its legislative power. Here it is executive power which we have done, but followed from a legislative action, section 53, 54. The Constitution Bench in M. Ramatha Pillai has approved their view in American jurisprudence that doctrine of estoppel will not be applied against the state in its governmental, public or sovereign capacity. It further held that only exception with regard to the applicability of the doctrine of estoppel is where it is necessary to prevent fraud or manifest injustice. The analysis of all the judgments of this court on this issue would reveal that it is a consistent view of this court, reiterated again in Godfrey Phillips, that there can be no promissory estoppel against the legislature in the exercise of its legislative function. Undisputedly, the notification dated 18/7/2017, withdrawing the exemption notifications issued in pursuance of the statutory mandate as provided in Section 174 of the CGST Act. If the contention as raised by the appellants is to be accepted, it would make the provisions under the proviso to Section 174(2)(c) of the CGST Act redundant and otiose. The legislator in its wisdom has specifically incorporated the proviso to Section 174(2)(c), providing therein that any tax exemption granted as an incentive against the investment through a notification shall not continue as privilege if the said notification is rescinded. If the contention is accepted, it will amount to enforcing a representation made in the OM dated OM of 2003 and 2003 notification contrary to the legislative incorporation in the proviso to Section 174(2) of the CGST Act. In other words, it will permit an estoppel to be operated against the legislative function of Parliament. We are therefore of the considered view that the claim of the appellant on estoppel is without merit and deserves to be rejected. This withdrawn was done while, Lordship. It was because in 2017 the new regime came, CGST Act. So in our case, we could have done the same thing. All this entitlement certificate, exemption certificate, we could have withdrawn it by issuing a notification. What we have done, we have issued a separate notification to extend it, the reverse situation of the central government. The existing exemptions from 2003 onwards were withdrawn in view of Section 174(2). So our scheme also came in 2017 only, post GST regime. I have placed this Extending the benefits, extending the benefits, state share. state share part. It is further to be noted that this court is of has also consistently held that when an exemption is granted earlier is withdrawn by a subsequent notification based on a change in policy, even in such cases, the doctrine of promissory estoppel could not be invoked. Here, back to CGST and AGST. There is a change in policy, change in tax regime. We could have done that also. We have two options open. One to stop it, one to extend it. We adopted the second one, on the basis of which he got 3 years additional part to complete his 7 years period. It has been consistently held that where the change of policy is in larger public interest, the state cannot be prevented from withdrawing an incentive. May I read it again? It has been consistently held that where the change of policy is in larger public interest, the state cannot be prevented from withdrawing an incentive which it had granted through an earlier notification. Reliance in this respect could be placed in the judgment of this court in Kasinka, Sirji, then Mahavir Oil, Sri Divali. I have shown 3 or 4 of these. Recently, this court in Unicorn Industries, after surveying the earlier judgments of this court on this issue, has observed 26th paragraph. It could thus be seen that it is more than well settled that the exemption granted, even when the notification granting exemption prescribes a particular period till which it is available, can be withdrawn by the state if it is found that such withdrawal is in public interest. In such a case, the larger public interest would outweigh the individual interest, if any. In such a case, even the doctrine of promissory estoppel would not come to the rescue of the persons claiming exemptions and compel the state not to resile from its promise.
if the act of the state is found to be in public interest. We are therefore of the considered view that even on the ground of change in policy, which is in public interest or in view of the change of statutory regime itself on account of the GST Act being introduced, as in the instant case, it will not be correct to hold that the union bound by the representation made by it in the OM of 2003. Further, this would be contrary to the statutory provisions as enacted in section 174(2) of the CGST Act. There is another reason which in our view would disentitle the relief as claimed by the appellant before the High Court. The appellant in effect are seeking a writ of mandamus against the union to reimburse 100% of CGST for the remainder of the period instead of only 58%. Paragraph 85. It could thus be seen that in none of the aforesaid cases the issue was to whether on account of change in the law, the state was bound to stand by its representation made under the earlier law, even when the change in law does not permit it to do so, till for consideration. Against this court in a catena of judgment, including 2 constitution bench judgment, a 4 judges bench judgment, and various judgment of the learned 3 judges, have consistently held that promissory estoppel would not apply against the exercise of legislative powers of the state. As such, none of the judges' judgments cited in our view would be of any assistance in the case of the appellants. Paragraph 98. This is what I was referring in the morning, Lord. Paragraph 90. It could thus be seen that GST Council has noticed that the central and the state government had given various incentives of central excise and value-added tax and CGST, central sales tax, so as to encourage investment in those states. It also took notice of the fact that such incentive could not be continued as supplies would need to be made on payment to tax to permit flow of tax to the destination state. The solution that could be suggested was to provide the budgetary apportionment of the state and the central budget for reimbursing the tax paid to those units which enjoy tax exemption so as a specified period. So basically, this is the handle given by the Supreme Court as well as by this GST Council. So GST Council also, and it was born out of a provision of the Constitution, Article 279, if I'm not wrong. So these are the law, well settled law, Lordship. So many judgments of Constitution bench, 4 judges bench, 3 judges bench. Everywhere it is said, if there is public interest, then the government cannot be compelled to invoke its promise. But in our case, there is no promise at all. Whatever was promised, it was delivered. So far as discrimination part of Article 14 is said, those who got the benefit, those orders were passed when the section 4 was pre-amended, not post-amended. The amendment came on 30th December 2020. Let them show a single case that post 30th December 2020, we have given any benefit freshly. Suppose somebody has got that benefit in 2018 with a period post December 5th. That is permissible. We are not withdrawing that. But no fresh case or no pending cases will be considered post 30th December 2020. If I am allowed to place it once more for my conclusion. What exactly was amended? Let us first see the amended part and post-amended part. Amended. Yes, pre-amended is at page 165, clause 4. If Lordship is pleased to come to page 168.
determination of the amount reimbursable. Subject to other provisions, the amount reimbursable under this scheme to the eligible unit shall consist for existing units eligible under the industrial policy of 2008. So I'm skipping all these things. Proviso, provided that if an existing eligible units, including a mega unit, there are all kinds of industries are included here in subsequent provisions, to which the customized tax incentive have been granted, is unable to utilize or avail the full amount of monetary ceilings within the specified period of exemption, it may make an application to the Finance Taxation Department for extension of period of eligibility. Such examination, upon examination of such an application, if the Finance Taxation Department is satisfied that the unit could not have achieved the full quantum of monetary ceiling due to some genuine reasons, this requires assessment. And in order to sustain the industrial unit, it is necessary to extend such time. It may, by an order, extend such time limit by further period not exceeding 5 years. So this is what we have amended. If now Lordship is pleased to come to page 217. There are some amendments to clause 4(2). In the principal scheme, clause 4 in subclause 1, there are certain punctuation marks and savings clause. Notwithstanding the omission of the provision of the said scheme, as mentioned in clause 2, clause 2, all orders issued thereunder by the Finance Department for extension period of eligibility shall be deemed to have been validly issued as if the scheme has not been amended. Further, all pending applications on which order of extension of period of eligibility has not been passed shall be deemed to have been rejected. So their application was pending. And others, if we look at the amendment of 2, para 3, subpara 2 shall be omitted. So those extension period, everything was omitted. So there has to be a cutoff mark. So the cutoff mark started from this date. Whoever got the benefit prior to this, they got it. Because at that point of time, when their cases were considered, it was not required for the state to generate additional revenue to tide over.
Where is their application for extension of this benefit? Is it available here?
Yes, yes.
18(8).
The
read petitioner's application, it is available. I got the date from the document only. Yes, 214.
It was on 18(8).
18(8) to 2020. Just 1 month prior to the expiry date. So this is my humble submission. So absolutely no case is made out, and therefore the repetition, all the repetition deserve dismissal. So my, I'm closing my part, Lord. My colleague will be here.
So this will sum up for all the
Basically the same issues. All issues are same. In case if any further clarification, then Lordship will give me time. Otherwise, I have closed. I have a review matter in another court. That's why I'm.
Yes.
But in fact, I'm not going to make a detailed submissions, reply. The Honorable Advocate General has stressed on 2 issues.
Before you open up, I am informed that 3:15.
I will finish within 10 minutes.
Ah.
I will not take more than 10 minutes. First, the Honorable Advocate General was arguing that because of the fund crunch in December, this has to be amended. I will also see the extension which was given to the other industries was in November. November 2020. Now, it's not so. The corona has come in December and the fund crunch only started in December. When you are giving an industry an extension in 2020 November to some industry and keeping my application pending from August, then the fund crunch is not applicable into respect of that industry. It is only applicable in respect of my industry. My lord, the classification which I am challenging before Lordship is that, my lord, the classification between an industrial unit in respect of which you pass an order and in respect of industrial unit in whose case you don't pass an order and keep it pending. My lord, if fund crunch is the issue for withdrawal, then I think the corona was from 2020 April itself. In between that, you give to all other industries the extension and deny to me by keeping the application pending. The Renish Advocate General was arguing that after the withdrawal, no extension was granted. There is no question of granting an extension after withdrawal. After you have withdrawn the clause, proviso, where is the question of granting any extension to any industrial unit at all? And my case was also not that you have granted the extension after 2020 amendment and you have not granted to me. No. My case was pure and simple, my lord, that number of industrial units you have granted the exemption. I have given one copy. In November also you have granted the exemption. Whereas I submitted my application in August. And that was not considered. Whereas somebody else's application was considered and pending applications were rejected. I don't know when the application for this industrial unit was filed. That is not available to me. The Rani Advocate General also argued that the application has to be filed before the expiry of the date of the eligibility. My application was filed in August, whereas the exemption period was expiring in September. Although I feel that from the reading of the proviso, the application can be considered only after the expiry of the period. Because the proviso says, my lord, that if a person had not been, industry had not been able to utilize or use the amount within the period, then he can be granted an extension. So it can be only after expiry of the period that the government can consider whether he should be granted an extension or not. So the discrimination which I am alleging in the present case is, my lord, the hostile discrimination between the two industrial units in respect of one, you pass an order just 1 month prior to the amendment, and in another case you keep it pending, don't pass an order. And deny the benefits. The industrial unit to whom the exemption was granted extension was granted, he shall be enjoying the benefit, he has enjoyed the benefit during the entire corona period. He has been granted exemption up to 25. So from 19, 20 to 25, if fund crunch was the issue, how an industry has been granted the exemption from 20 to 25. Now corona is not there, still is enjoying. Article 14 also, my lord, not only arbitrary but unfair. Even legitimate expectation also comes within the purview of Article 14 of the Constitution of India. My application also you could have considered on merits and rejected it. And if a lordship looks into the order which has been passed for extension in another case, you'll also find this is a mechanical order, not considering the factors which are given in the proviso. The power conferred under the proviso is not a discretionary, unfettered discretionary power conferred on the government to grant the extension in one case and to deny the extension in another case.
Yes.
Now, my learned friend was again, I'm just 3 or 4 issues which he touched it. That I made a wrong calculation, give my production details wrongly. I could not achieve the target. The exemption limit is not on the basis of the production. The exemption limit is based on the capital investment. 100% of the capital investment, on the basis of that, the limit is determined. And it is not because of my inefficiency that I could not meet the total limit, but it was the reason that after the introduction of the GST, the CST exemption which was available earlier was not available. Secondly, earlier the VAT full rate was there. Now, after the introduction of GST, it has become CGST and state GST, half state GST, half CGST. So the benefit which was I was getting during the VAT period of the account of tax, that was reduced. So it is not to say that I gave a wrong projection and it was because of inefficient production or operation of my factory that I could not avail the benefit. If that was so, the same applies to the another industry unit who could not also avail the benefit and was granted 5 years exemption. If one treats my industry unit to be inefficient and thereby not entitled to the benefit, then the similar parameters should be applied to the another industry unit to whom you have granted the exemption. And if that is the parameter, my lord, then the proviso, there will be no meaning at all. Because the proviso provides that those who could not avail the benefit within the time prescribed may be granted the extension. So that means all those industrial units who are granted the exemption by extension of the period were all inefficient. And if that be so, then how you are discriminating between the me and those industry units? If that is the parameter, then they also stand at the same footing to me also. There is no distinction. In fact, you knew that in December you are going to withdraw it, and prior to that, in the stage which you wanted to give, you have granted the extension. And to the industry unit which you wanted not to give it, you just keep it pending. So, my lord, this is a clear case of the violation of Article 14 of the Constitution of India, where equals have been treated unequally, and thereby, insofar as the last part of the proviso that those applications who have been kept pending shall be deemed to have been rejected, that is hit by Article 14 of the Constitution of India. The learned AG was insisting again and again on the promise stopper, that no promise was made by the 2020 amendment, by the 17 policy. Well, the promise stopper which I pleaded is based on the conjoined 2008 and 2017. 2008, you said that you will be entitled to the CST exemption as well as the VAT exemption, full exemption. Now, by the amendment in the GST, introduction of GST, and by the withdrawal of the earlier exemption, those benefit was taken away. If that would have been the end of the matter, those judgments which my learned friend was placing would have any relevance. But if after withdrawal, you give the benefit so as to give the benefit what was promised in 2008, that is an extension of the promise which was made in 2008, and thereby the question of promise estoppel comes. If after withdrawal you have not announced it 2007 policy itself, then perhaps the judgment which my learned friend has placed before Lordship would have any application in the case.
The scheme, does it reflect that it is in continuation of the policies?
It says the promise which was made in 2008 and 2014.
Let us see the scheme. again.
Industrial policy, you're asking me, see?
No, this scheme.
Yes, 2017 scheme.
Ah.
I will just point out to that, Lordship, and I will close it, Your Lordship may see the scheme. At page 165.
Can we continue tomorrow?
I finished it. Because there is nothing
there may
yet, are we legally only?
There may be certain queries.
If you also wants to, my lord.
No, the scheme of 2018.
My
That's
lord,
what we are
at
referring.
page 165 and at page 166, last paragraph, my lord.
The measure of goodwill.
Goodwill is all right, my lord, but what, to whom it has been given? So those in the existing industry units in the state of so-and-so investment policy of 2008. Or under the industrial policy of 2014 and covered by the earlier schemes.
All right.
There is nothing like goodwill, my lord, in the government, whatever it is, everything is goodwill.
Yes.
The amount they will give is always, my lord, the exemption also they give is a goodwill.
Yes.
Can there be anything like goodwill, my lord?
Lordship, tomorrow morning we'll give the written argument, whatever learned AG has submitted before your lordship, and the application with regard to that party to whom the extension was lordship, I have just received in my WhatsApp. I will bring and that also in APDP.
Then we'll keep
That,
it for tomorrow. We'll keep it tomorrow after rising of the DP, which will be around this time.
Or lordship, that document that I can annex it in the return.
Can annex it, but you are how can you annex it with the written?
No, lordship, since that submission was, I just received in the WhatsApp the date of
Alright.
application,
That's all right.
reflecting.
What we are saying is, once you place it
Yes.
before the court, we have to take judicial notice. And
Yes, sir.
you have to give copies to the other side.
I will.
There may be certain
Yes,
queries.
lordship, then lordship may fix tomorrow or any other date.
No, tomorrow it will definitely.
We'll keep it tomorrow. If you say it is convenient for you tomorrow, we'll keep it tomorrow.
Yes, anytime, lordship. Tomorrow.
And after my lord, whatever he gives, thereafter we'll file a written. Hmm? Cool. Yeah, no. It will not change anything.
Okay.
The earlier written argument has to be discarded because below that was given on the 8 or 10 cases. To give a phrase,
You want us to discard?
Lord, everything, the judgments, etc., everything you also may discard. We'll give you an entire compilation.
All right, we'll continue tomorrow then.
Tomorrow,
this time.
Look at the follow-up with you.
Yes.